Yes,
May-
Mr. Chaudhary, you want to make a mention?
No. I just thinking.
May-
Yes.
Regarding item number 9, my lord, that my senior was conducting the case, my lord. After his death, my lord, all cases are conducting by his son. He is also advocate and other junior. But we, my lord, made communicate with that client, my lord. But there is no response. That is why we could not, by overstepping, giving notice to him also, my lord. So our problem is that this case is regarding essential communities. I have just gone through the record, my lord, that FIR has been lodged, my lord, because stealing of some cylinder, my lord.
Today
There
it
was
was fixed because on the last occasion there was.
yes,
no
my lord.
representation.
That I contacted. He also said that we have no instruction. How could I? Because we have no communication since
No
then.
communication is another thing, and when a name is there, then
Yes, my lord, name is there, my lord.
Yes.
I could
cannot
understand. That's why,
be.
my lord.
You are not otherwise in this matter. Your name is there.
My name is also there, my lord.
Then
So, my lord, that
you either you send and what instruction do you need? It's a criminal petition.
yes, my lord, not
What
necessary, my
instruction
lord.
you need?
Your lordship may take up the matter of only thing, my lord, that may get a
When you,
copy, my lord.
in item number 9, you write this matter. Your name.
C. Goswami.
Heard Mr. C. Goswami, learned counsel for the petitioner. Also heard Ms. S.H. Bora, learned APP for the state respondent. This matter was listed today in the order column with the remark for dismissal as there was no representation on behalf of the petitioner on the last occasion. Stop. However, in view of Mr. C, the petitioner being represented through Mr. C. Goswami, learned counsel, list this matter for hearing next week on a date to be fixed by the registry.
Well, I may be allowed to take a copy here, my lord, because
You-
highly do it
you
my
take-
senior.
You take it.
My lord.
Photocopy কৰি দিব.
Obliged.
You be prepared. Yes. Yes, Mr. Halloy.
With regard to item number 25, Lordship, I'm appearing on behalf of the respondent, private respondent, Lordship. 25, Lordship.
25.
Due to some personal difficulty, I'm not in a position.
Have you informed the other side?
No, Lordship, I'll inform you.
Huh?
There's a stay order, Lordship. Let the stay order be continued.
No, but you have not informed.
I have
the
not,
other side.
because phone number is not available with me.
No,
I'll
Mr.
inform.
M.K. Sharma and all, then you'll have to wait or you ask your junior to be here because they are the petitioner.
Yes, Lordship.
Next.
My lord, item number 26, I am for the petitioner. I am not pursuing the matter. I want to withdraw the
You want,
petitioner. I want to withdraw, my lord.
in item,
Opposing party is also there.
item number 26.
26.
Heard Mr.
Ayat Talukdar.
I. Talukdar. Also heard Mr. Jiuddin,
Yes.
learned counsel appearing for respondent number 2 and Ms. S.H. Bora, learned APP for the state respondent. Mr. Talukdar, learned counsel for the petitioner, submits that he has been instructed by the petitioner not to press the instant criminal petition and accordingly seeks withdrawal of the same. Prayer is allowed. Petition stands dismissed on withdrawal.
May I please, my lord? My lord, I beg to mention that one criminal petition 929 of 2024 may kindly be listed as soon as possible. Because after stay was granted, the matter was not listed.
Make the mention before the appropriate bench. Yes, next.
My lordship, I beg to mention item number 4 of today's list, my lordship. My senior advocate, Mr. An Islam, has suffered brain stroke, my lordship. He's going through a speech therapy.
You are for
An Islam.
for whom? For the petitioner.
Petitioner. I've already taken consent from the other side.
And put a respondent number 2.
Your name?
TK Day on behalf of An
Mr.
Islam.
TK De, learned counsel for the petitioner, submits that Mr.
An Islam.
and Islam learned counsel appearing in this appearing in the matter has suffered brain
hemorrhage. It is written.
has suffered brain hemorrhage and accordingly seeks accommodation in the matter. Prayer is not opposed by MS.
RS theory, my
RS Theory, learned counsel appearing for the respondent. Relist after 4 weeks on a date to be fixed by the registry.
Deeply obliged.
Lordship, I beg to mention item number 10. Matter has become infectious, Lordship.
Your name?
MJ Gogoi. I am appearing Mr. On behalf of Mr. Ekedas.
Mr.
MJ Gogoi.
MJ Gogoi, learned counsel, appearing for the petitioner on behalf of Mr. A.K. Das, submits that in the meantime, the transfer criminal petition has become infructuous. Stop. In view of the aforesaid endorsement made by the learned counsel for the petitioner, the matter stands dismissed on being infructuous.
All right, deep.
Please, Lordship. Lordship, I beg to mention item number 5, Your Lordship. Matter may be adjourned for the day, Your Lordship.
Why?
Lordship, senior counsel out of station, Your Lordship.
Out of?
Out of station, Your Lordship.
You are for the respondent?
Respondents.
I am for the respondent, my lord.
You are for the respondent?
Yes, madam.
Are you, any objection?
My lord, the matter is pending for a long time and it's a very small matter, my lord. Because of there is delay of only 1 day in filing a complaint petition under section 138 of the NI Act. That is why the matter was pending for the last more than 5 years here. My lord, only for 1 day delay, that delay was also
Delay
not
has been
justified.
condoned.
My
Delay
lord,
condoned.
My lord, in fact, there was no delay at all.
No, whether delay has been condoned or not.
Not condoned and whereas the
Item-
complaint petition
item
itself was dismissed, my lord.
5, Your Lordship.
Item 5 is a criminal petition. There is no delay application.
No, my lord, the original complaint petition was filed.
Acha.
It is stated by the court below that in filing the complaint
There has
petition
been a
under
delay.
138, there is delay of only 1 day. But in fact, there was no delay at all. And my complaint petition was dismissed outright.
All right. When do you want it?
Your Honor, weeks.
Not 2 weeks. Next week. Your name?
R. Borman.
Mr. R. Barman, learned counsel, appearing for the petitioner,
Respondent number 2.
appearing for the respondent number 2. Oh, you are for the respondent.
Respondent.
Appearing for the respondent number
Yeah,
2, seeks accommodation in the matter on the ground that the senior, that his senior who is conducting the brief is out of station. Mr.
AK Jain.
A.K. Jain, learned counsel, appearing for the petitioner, strongly opposes the prayer on the ground that the matter is pending for a long time. However, be that as it may, by way of a last chance, the matter is adjourned to any date next week. To next week or next week. Stop. Let registry relist the matter on a date.
My lord, that may kindly be fixed if possible.
Okay, relist on such and such date. Adjourn, adjourn or whatever. Be that as it may, relist on so and so. Yes, please.
22 minutes.
On that day, if your senior is not there, you better be prepared. No further accommodation. Yes, Mr. Nath, are you armed with anything?
So before your lordship passes his judgment, my lord may kindly allow my learned friend to assist.
No,
point of-
nothing like this. Arguments are over. This matter was only posted today for
I have worked for the
giving me
provision-
any judgment if you wanted
Yes.
to give. So if you have a judgment, please pass it.
Can my learned friend assist me?
Mr. Nath,
In Priyawala Ghosh, my lord,
yes,
like the similar facts have been here, my lord, on the basis of the evidence of the priest.
evidence of the priest.
My lord.
Okay,
Conviction was. Well, para 9, my lord. Your lordship, please. Para
yes.
9 starts from 1, 2, 3.
Read it slow.
Yes, both the contentions of the learned counsel for the appellant can be dealt with together. It can be pointed out by the session judge that both sides agreed that according to the law prevalent amongst the parties, Homa and Saptapadi were essential rights to be performed to constitute a valid marriage. Both sides also agreed before the court that there was no specific evidence as to the performance of the Saptapadi and Homa in the case of the alleged marriage of the respondent with Sandhya Rani. Therefore, the main question that has to be considered is whether the performance of the above ceremonies
This
and rites.
judgment is from is of Calcutta High Court.
Yes, ma'am.
Is it Calcutta High Court or the Supreme Court?
Supreme Court judgment went from the Calcutta.
Yes.
Therefore, the main question that has to be considered is whether the performance of the above ceremonies and rites have to be established by evidence, especially before the respondent could be convicted under 494. The findings of the High Court are that the priest, that is the PW6, who claims to have officiated the marriage of the respondent and Sandhya Rani has given evidence to the effect that the marriage was solemnized according to Hindu rites. He has not said anything more than this. The other evidence adduced has not been considered to be of any use in this regard. The further finding of the High Court is that no evidence was adduced that the Homa and Saptapati were performed in the case of the marriage between Sandhya Rani and the respondent. That it has also not been proved that there was any custom prevalent amongst the parties that those essential ceremonies are not necessary for the purpose of solemnization of the marriage. According to Mr. Majumdar, once the priest has given evidence to the effect that the marriage between the respondent and Sandharani has been performed, it follows that all the essential ceremonies that are necessary to constitute a valid marriage must be presumed to have been performed. In any event, when there is evidence to show that the marriage as a fact has taken place, the presumption is that it has taken place according to law. In this connection, Mr. Majumdar referred us to the various English decisions where on the basis of certain evidence regarding the taking place of the marriage between the parties, a presumption has been drawn that the marriage must have been solemnized according to law. In our opinion, it is unnecessary to refer to the decision cited by the court. Can my lord kindly come down to, we have pointed out just few lines.
Where?
Few lines,
Yes,
my lord.
yes, we have
We have pointed out that in case before us, both sides were agreed that according to the law prevalent amongst them, Homa and Saptapadi were essential rites to be performed for solemnization of the marriage. And there is no specific evidence regarding the performance of these essential rites. The parties have also not proved that they are governed by the custom under which these essential ceremonies need not be performed. Then, my lord, may kindly skip to paragraph 17, my lord. They have relied on certain the Supreme Court is Hindu law and
Let's read from 16.
16. From the above quotations, it is clear that if the LS second marriage is not a valid one according to law applicable to the parties, it will not be void by reason of its taking place during the life of the husband or the wife of the person marrying so as to attract provisions of 194. Again, in order to hold that the second marriage has been solemnized so as to attract section 17 of the Act, it is essential that the second marriage should have been celebrated with proper ceremonies and in due form. In the said decisions, this court further considered the question whether it has been established that with respect to the LS second marriage, the essential ceremonies for a Hindu marriage have been performed. After referring to the passages in Mullah's Hindu law 12th edition dealing with the essential ceremonies, which have to be performed for a valid marriage. This court on the evidence held that the prosecution has neither established that the essential ceremonies have been performed, nor that the performance of the essential ceremonies have been abrogated by the custom governing the community to which the parties belong. In this view, it was held that presumption or prosecution in that case had failed to establish that the alleged second marriage had been performed in accordance with the requirement of section 7 of the Act. To the effect of this decision, in our opinion, is that prosecution has to prove that the LS second marriage had been duly performed in accordance with the essential religious rites applicable to the form of the marriage known so by the parties, and that the said marriage must be valid according to the law applicable to the parties. So ultimately, paragraph 25, my lord, the Honorable Court has concluded that we have already referred to the fact of both the learned sessions and categorically found that Homa and Saptapadi are essential rights, and ultimately conviction was set aside. So in our case also, merely based on the evidence of the PW 6, who is the priest.
But what does this mean in para 16?
16.
From the above quotations, it is clear
Clear
that
that
if the
if the
alleged
alleged
second marriage is not a valid
Valid
one,
one,
according to
the-
law applicable to the parties,
not be
it will
void.
not be void by reason of its taking place during the life of the husband or the wife of the person marrying, so as to attract section 494 IPC.
But
What does
says,
it mean?
My lord, to become a marriage void, my lord, it has to be a valid marriage first. If unless it is a valid marriage,
No, but if suppose
not-
the marriage is void, then what about section 494? It is attracted or not
yes,
attracted?
attractive.
It
If
is attracted.
void,
So here, suppose in a given situation, assuming that some steps is required,
Yes.
and that nobody have said.
Yes.
The priest also doesn't say.
Yes.
In that situation, that marriage becomes void.
No, that marriage will not become valid. So
Not valid
unless
means
it
it
is
is
valid,
void.
it will not be
What
void.
is not valid?
Valid means it has to be in due form and proper ceremonies when it is performed, then
Correct.
only it is
Now,
said to be
now,
valid.
I think that that day we had, which was that case?
Gopal Lal.
Hmm?
Gopal Lal.
Gopal, correct. Gopal Lal, right?
Gopal Lal, my lord, there are evidence which of the DW, PW 2, 3, 4,
Gopal Lal
5,
is of 79. This is of
which says
71.
that certain ceremonies were performed.
Gopal Lal is of 3 judges. No, 2 judges and subsequent to 71. Let's see Gopal Lal.
Right. Gopal Lal starts from paragraph 5.
In Gopal Lal, this decision was relied.
Yes, relied.
Relied. Priyabala Ghosh.
173 by lord. Page starts from it was thus.
Yes, Priyabala Ghosh
There was
relied.
relied.
Yes, let's read this because this is the judgment which the appellate court had relied, correct?
Yes.
Let's read.
It was thus pointed out by
Where are you reading from?
this, in the middle
Come,
portion,
come
my-
to para 5. Let's read from para 5 again.
what section 17
From para 4.
4.
Let's start from para 4.
4. It may also be noticed that section 494 IPC would come into play only if the second marriage becomes void by virtue of the fact that it had taken place in the lifetime of one of the spouses. Thus, it is not possible to accept to the contention of the mullah that merely because the second marriage was void under section 17 of the Act, section 494 would not be attractive. Section 17 of the Hindu marriage is thus runs. Thus, any marriage between two Hindus solemnized after the commencement of this act is void if at the date of such marriage either party had a husband or wife living, and the provisions of 494 would apply accordingly. Section 17 contemplates that the second marriage must be according to the ceremonies required by law. If the marriage is void, its voidness would only lead to civil consequences arising from such marriage. Section 17 makes it absolutely clear that the provision has to be read in harmony in conjunction with the provisions of section 494 IPC, which has been extracted above. Section 17 clearly provides that provisions of 494 and 495 shall apply accordingly. In other words, though the marriage may be void under section 17 by reason of the fact that it was contracted while the first marriage was subsisting, the case squarely falls within the four corner of section 494. By contracting the second marriage, the accused incurs the penalty imposed by the statute. Thus, the combined effect of the section 17 of Hindu Marriage Act and section 494 is that when a person contracts a second marriage after coming into force of the said act, while the first marriage is subsisting, he commits the offense of bigamy. This matter is no longer res indiga as it is concluded by the decision of this court in Aurao Shankar Lakhande versus Maharashtra. This court, while considering the question of bigamy, were the provisions of section 17 observed as follows. Section 17 provides that any marriage between two Hindus solemnized after the commencement of the act is void if at the date of such marriage either party had a husband or wife living, and that the provisions of 494 and 495 shall apply accordingly. The marriage between two Hindus is void in view of the section 17 if two conditions are satisfied. The marriage is solemnized after the commencement of the act, that at the date of such marriage either party had a spouse living. If the marriage which took place between the appellant and the Kamlabai in February 62 cannot be said to be solemnized, that marriage will not be void by virtue of section 17 of the act. Then section 494 will apply to such parties to the marriage as had a legal spouse living. The word solemnize means in connection with a marriage to celebrate the marriage with proper ceremonies and in due form. According to the Oxford Dictionary, it follows therefore that unless the marriage is celebrated or performed with proper ceremonies and in due form, it cannot be said to be solemnized. It is therefore essential for the purpose of section 17 of the Act the marriage to which section 494 IPC applies on account of the provisions of the act should have been celebrated with proper ceremonies and in due form. It was thus pointed out by this court that section 17 of the Hindu Marriage Act requires that marriage must be properly solemnized in the sense that necessary ceremonies required by law or by custom must be duly performed. Once these ceremonies are proved to have been performed, the first marriage becomes properly performed, the marriage becomes properly solemnized. And if contracted while the first marriage is still subsisting, the provisions of 494 will apply automatically. In a decision of this court in Kamal Ram versus Himachal Pradesh, the earlier case was noticed by this court and relied upon. The matter has also been fully discussed in Priyawala Ghosh. In view of the authorities of this court, therefore, the following position emerges: where a spouse contracts a second marriage while the first marriage is still subsisting, the spouse would be guilty of bigamy under section 494. If it is proved that the second marriage was a valid one in the sense that necessary ceremonies required by law or by custom have been actually performed. The voidness of the marriage under section 17 of the Hindu Marriage Act is one fact, one of the essential ingredients of section 494. Because the section 494, because the second marriage will become void only because the provisions of section 417 of the Hindu Marriage Act. In these circumstances, therefore, we are unable to accept the contention of the Mr. Mullah that the second marriage being void, section 494 will have no application. It was next contended by Mr. Mullah that there is no legal evidence to show that there could have concurrently found as a actually second marriage, which is we are afraid we are unable to go into this question because these courts have concurrently found as a fact that the parties were governed by customs of muta marriage, and the two essential ceremonies of this marriage are that the husband should take.
All right. Let's go back to the appellate court's order once.
37, my lord.
1 second.
57.
Page
57.
57.
Yes, sir.
Yes.
Starts from 59, my lord.
Let's just come to the operating part.
Yes.
Maybe you can read from 6.
Ma'am. According to PW1, Dipti Rani Devi, she was married with accused Bhupennath on 1993. And when her husband was suspended in 1999 from his service, he sent her to her parents' house and started to live separately. And on 2000, he married Sri Aratinath at Paglatak temple. He has also stated that out of the second marriage, one son was born, and she has not yet divorced by her husband. Supporting of the evidence of PW1, PW2, Horeshwari Rai has stated that on 93, accused Bhupennath married Dipti Rani Devi as per Hindu customs, and one son was also born out of this wedlock. And later the
PW2 said living, na?
yes, leaving.
Okay. PW3.
PW3, Madan Kumar Rai has also stated that accused Bhupennath had remarried another girl without divorcing his first wife.
PW6.
6, Anil Chakraborty has stated that he is the priest of Paglatek temple, and on 2000, accused Bhupennath married Artinath in his temple in the name of Bhuvaneshwar. Exhibit 2 is the marriage certificate, and Exhibit 2.1 is the signature of Bhupendranath given by the accused Bhupennath. He has also stated that in course of investigation, police has seized the Exhibit 2 from his position. In his cross-examination, he stated that the marriage was performed in his Shiv temple as per Vedic rites. PW7, Padmavati Devi has also stated that Bhupennath remarried Aratinath during the lifetime of his wife Dipti Rani Nath. She has also stated that accused Bhupennath lived in front of her house with his second wife Aratinath. PW8, Keshav Chandranath has also stated that accused Bhupennath remarried another girl and one son was born out of the second marriage. PW9, SI Nil.
All right. Para 8. Sorry, I'm going a little fast.
No, no more.
Uh,
After going
yes.
through the evidence of the contending parties, the admitted position is that in Golpara Civil Hospital, one child was born on 2001 and father's name was recorded at Rupen Nath. Exhibit 2 shows that
The marriage certificate is available.
yes, sir.
Please, Ms. Bora, just please point it out.
Yes.
Yes, please.
Exhibit 2 is the marriage certificate on Arati Nath with Bhubaneswar Nath. On 6 to 2000, as per customary law, the priest of the temple PW6 Anil Chakraborty had categorically stated that it was accused Bhupen Nath, who impersonating as Bhubaneswar Nath, had married.
Hindu customary law, he had denied that suggestion.
Yes, ma'am.
That is where, because in his chief, I think it's Vedic rites.
Vedic rites.
And there he said
He
Hindu.
denied. Religious ceremonies were performed. He denied.
Yes.
PW7 Padmavati Devi has also categorically stated that accused Bhupen Nath had remarried Arati Nath and they lived in a house in front of her house and one male child was born out of his wedlock and his name is Bhargav Nath. In order to constitute the offense of bigamy under 494, there must be a first valid subsisting marriage at the time of second marriage. Here in this case, first marriage of the accused person with the complaint is admitted by the accused. In this case, I would like to submit that merely because there
Ms.
was
Bora,
an
the
admission.
finding of the appellate court appears to be perverse. Because the appellate court has said in the sense that the necessary ceremonies required by law or by customs have been actually performed. Where is the evidence?
Because as for the.
Where is the evidence? Evidence is only Vedic rights.
Yes, so that includes lordship prayers.
If you go by the two decisions which have been cited by the other side, it says near saying Vedic rights or Hindu rights will not be sufficient. It has to be shown what are the steps taken for contracting that marriage. Suppose it is Hindu marriage right, what are the steps required? Whether those ceremonies, those steps have been taken or not taken, something has to be more. They have in their cross, they have said that it has not been done, though that suggestion has come, they have denied. But what are the ceremonies?
But PW6, who has categorically stated that as for Vedic rites.
Vedic, but what Vedic rights? What
yes,
were those steps?
in those,
Mr. Nath is correct in his submission to that effect
yes.
that there was no, there is no evidence of what ceremony is being performed.
But that
Because if you
specific
see
submission
the decision which he has cited today is very clear. It's very clear. There it says the ceremonies has to be performed. Now one cannot merely presume that these ceremonies have been performed because there is a certificate A or because the priest says that it has been done as per the Hindu.
This PW6 person is also corroborated by the other
To
evidence.
what extent PW2 says it's a living relation. She simply says living, and the other people, they are not the witness to the Ms. Bora, please keep in mind, because they are not witness to the marriage. How can they say? They may have assumed it, and there were some witnesses. I think it was, where was the list of witnesses which were not examined, who is said to have witnessed the marriage?
The evidence of the priest, he has said there are other witnesses. Who
Who are these witnesses?
Yes.
Why they have not been brought on record? They could have thrown light.
Right.
But
It's highly doubtful, and if there is a doubt, why shall benefit should not be given to the accused?
the other way also, lordship, in his cross-examination, no such suggestion was put.
See,
the-
Ms. Bora, please have a look at that decision. You have a copy of that decision which you just cited?
Well,
Please give it to Ms. Bora.
we have-
Just highlight that part and just show it to her.
So far as the other evidence, other PWs who have said that they have seen, that is not relevant as per section 50 of the evidence.
We don't have to go
Right.
so much to that extent, Mr. Nath. The finding of the concurrent finding has to be first of all based on evidence.
Right.
The evidence of contracting a valid marriage under section 17 has to be there. The decision that you're relying clearly says
Yes.
that mere Hindu rights will not be sufficient.
That's
That's why I asked you for that certificate. Anything is mentioned in that certificate because it's an exhibited document.
It's an
What?
exhibited document.
Yes. Now, why did the prosecution did not bring those witness? They could have, the fact that they have not been brought to the witness box, the inference will be drawn against the prosecution.
my lord.
Yes or no?
Yes. W6 has clearly said
Mr. Nutt, why were you hesitating to argue today? Why you wanted Mr. Bora to argue?
this. PW6 has said
1 second.
উপস্থিতি অভিভাৱক আৰু সাক্ষীসকলৰ আগত বিবাহ পাশত আবদ্ধ হৈ স্বামী স্ত্ৰীৰূপে জীৱন নিৰ্বাহ কৰিবলৈ প্ৰতিজ্ঞাবদ্ধ হয়। দৰা সদস্যতা কন্যা শ্ৰীমতী আৰু
I think there was one case where there was a certificate which the court says mere certificate will
Yes,
not
yes.
do. Which was that case?
it was Dolly Rani, my lord.
And the witness and number could have said.
বিয়োগৰ সাক্ষী
You have a copy of the certificate.
No, my lord.
You can ask Mr. Bora while you're arguing. Just in a piece of paper, please. Can you just or Ms. Bora? I want the names of the witness in that.
Okay.
Just put them in a piece of
PW6
paper.
okay.
How many witnesses?
PW6.
Which is that case? Which is that case? Doloy?
Dolly Rani, my lord.
Dolly Rani.
2025.
Yes,
too,
yes,
it's-
yes.
In this case also, there was a certificate stating that marriage was performed by him.
Yes, no, I remember. That's why I wanted to see this. But this is a
Whereas-
case under, you said it was for domestic violence, for
There was
divorce.
a divorce petition, but Supreme Court has said marriage was not even valid. So where is the question of granting divorce?
Because it is difficult for this court not to follow these decisions. In all these decisions, the Supreme Court in one word is repeatedly saying that in order for a marriage, valid marriage under the Act, the requisite ceremonies have to be performed. And there must be proof of performance of the said ceremony. I'm on that, Ms. Bora.
Yes, I do understand.
Where is this evidence?
But
This
he has
evidence is
simply
not
says-
there.
Categorically stated that as per Vedic rights.
Correct. But what about the ceremonies? How can we ignore the decisions of the apex court? Not just one, even if one cannot be ignored, but it has been repeatedly being held that for a valid marriage, there has to be evidence of ceremonies.
I think Vedic rights includes that's 7.
No, that presumption
Lots
has, the later case which he has relied today, has said that there cannot be any such presumption.
Yes.
In fact, on those presumptions, the high courts have, I think, the first court, I think, presumed,
Yes, my lord.
and then it was interfered. Presumption cannot come.
But no
There
such
has to be
submission was
evidence.
Also not put to the,
The onus is on whom? The prosecution has to stand on its own legs.
That's
The prosecution has to prove it. Where have you proved?
yes. Right. The lordship has a query regarding the other witnesses who has not been examined. So those persons were Himkesh Das.
Can you please put it in a piece of paper, their names?
Yes.
Because that is another thing which I need to, which perhaps will also be in support of Mr. Nath. Because these witnesses were available. What happened? There is nothing, whether they were available, why have they not been brought to the witness box?
Yes, no?
And were they a listed witness?
no, my lord.
No.
They were not even a listed witness. They can't be simply ignored. That I think that also makes the entire case of the prosecution fatal,
Right.
isn't it? Get hold of that decision. You look into a mobile, vital witness, non-examination, prosecution case vital becomes fatal. Just while I'm dictating, I'll add it later. You try and find out that.
Right.
All right, you give the names. I'm
Yes.
dictating the judgment.
PW.
Item 31, huh? Heard Mr. H. Nath, learned counsel for the petitioner. Stop. Also heard Mr. K. Sharma is the name of your senior. Mr. K. Sharma, learned counsel appearing for the respondent number 2. Respondent number 2 stroke informant. Complainant. Complainant
Yes.
stroke complainant. And MS SH Bora, learned APP for the state respondent. Stop. This application is filed under section 401 of CRPC 1973. Challenging the judgment and order dated 11/1/2011 passed by the learned session judge Gwalpara in criminal appeal number 3 of 2007, upholding the judgment and order passed by learned SDJM Gwalpara in GR case number 1047 stroke 04, convict whereby the petitioner was convicted under section 494 of IPC and sentenced simple imprisonment and sentenced
Rigorous imprisonment.
and
1 year.
sentenced. No, that is default. 1 year is simple, or please check and tell me.
Rigorous.
Huh?
Rigorous.
Rigor. And sentenced and sentenced him for 1 year rigorous imprisonment with fine of rupees 3,000 in default, 6 months of rigorous imprisonment. Stop.
6 months simple.
Hmm?
In default, simple.
No, it's written RI here in your cost title. Is it simple?
In default, simple.
In default, 6 months of simple imprisonment. Okay. Please check that otherwise. Okay, yes, you are right. It is in your cost title, you have said RI. That's why. Anyway, in para 5, you have clarified it. The brief facts of the case is that the respondent number 2 filed, lodged a complaint before the CJM Gwalpara, alleging inter alia that the petitioner married one Srimati Aroti Nath during the subsistence of her marriage with the petitioner accused. Now, accordingly, the complaint was sent to the jurisdictional officer in charge police station for inquiry. Thereafter, the jurisdictional police station, after inquiry, registered case number GR, case number 1047 of 2004, and filed charge sheet against the petitioner. Filed charge sheet under section 498A stroke 494 stroke 419 stroke 496 IPC. Thereafter, the trial court frame charge under section 498A stroke 494 IPC against the petitioner and conducted the trial. Stop. After the closure of evidence, the trial court where is the trial court's Trial court is page 17.
17, start from 17.
Convicted the petitioner accused under section 494 IPC and sentenced him
Page 28.
to undergo rigorous imprisonment for 1 year and sentenced him thereof, because I got quas. Situated thus, an appeal was filed before the Court of Session Judge Gwalpara. The appellate court by judgment dated 11/1/2011
Page 62. my
yes,
lord.
yes,
Last.
was pleased to dismiss the appeal, thereby upholding the judgment and conviction of the trial court. Stop. Against the aforesaid order of the appellate court, the present criminal revision petition has been filed. Stop. Mr. H. Nath, learned counsel for the petitioner, submits that the judgment of the learned appellate court as well as the trial court is based, is patently erroneous inasmuch as there is no evidence of the alleged second marriage to have been performed by following the requisite ceremonies. Stop. He submits that in order for a marriage to be valid under Section 17, Hindu Marriage Act, under Section 17 of the Hindu Marriage Act, the requisite ceremonies has to be followed. Inter alia, the requisite ceremonies has to be followed. Stop. He accordingly submits that the finding of the appellate court as well as trial court that there was a valid second marriage is totally perverse, and therefore the judgment of the appellate court is liable to be interfered with. In support of the aforesaid submission, he relies upon the following decisions. Able to me as per your kori diba, eta just likhi loa. Number 1, case number likhi diba. 2025 2 SSC 587. 2024 8 SSC 706. 1995 AIR 1965 Supreme Court 564. Gopali Kharu is also given by you.
Lekharu, my lord. Yes,
Given by you?
supposed to place this judgment.
No, because it is here otherwise.
Yes.
2005 4 GLT 77. Requisite ceremonies, no koba. Essential ceremonies. 1971 SSC 864. 1979 2 SSC 170. Per contra, Mr. K. Sharma, learned counsel appearing for the respondent number two complainant, submits that it has clearly come out from the evidence of the priest PW6 that he has conducted the second marriage of the accused petitioner with Aroti Devi, with one Aroti Devi, as per Vedic rites. He further submits that the same being he further submits that that PW6 has further exhibited the marriage certificate in support of the second marriage. He accordingly submits that there being evidence as regards the second marriage, based on which both the appellate court as well as trial court has held the petitioner guilty under section 494 of IPC, cannot be interfered by this court under revisional jurisdiction, inasmuch as there is no patent or manifest error whatsoever. Correct? Stop. MS SH Bora, learned APP, submits that the evidence of the priest PW6 is corroborated by the evidence of PW1, PW2, and PW7
And DW3.
and the DW3. And therefore, there is no manifest error apparent on the face of the record calling for interference of this court in exercise of revisional jurisdiction. Stop. Correct? That's your submission?
Yes.
I have given my prudent consideration to the arguments advanced by the learned counsels appearing for the contending parties and have perused the materials available on record. I have also considered the case law cited at the bar. Before adverting to the merits of the issue, apt to refer to section 17 of the I got Kodiba hereinafter of the Act 1955, which is reproduced hereunder for ready reference, quote unquote. Apparent that mere deposition by the witness that he had performed that he had performed second marriage of the accused with another person is not enough. The impugned marriage must, no, in order to attract the provision of section 17, the impugned marriage must have been solemnized. That is, the marriage should have been celebrated or performed with proper ceremonies in due form. In other words, if the marriage is not a valid marriage, it is no marriage in the eyes of law. Where is IPC? .494, right? Apt at this juncture to refer to section 494 of IPC, which is reproduced here under for ready reference, quote unquote. Perusal of section 494 IPC it appears that the essential ingredients of this offense are: one, that the accused spouse must have contracted the first marriage; two, that while the first marriage was subsisting, the spouse concerned must have contracted a second marriage; and three, that both the marriages must be valid in the sense that the necessary ceremonies required by the personal law governing the parties had been duly performed. What transpires from the above is that there has to be evidence to indicate that what transpires from the above is that to attract section 494 IPC, comma, there has to be evidence to indicate that the accused has married another person during the subsistence of his marriage with his first wife, and the marriage has been performed with the essential ceremonies required by the personal law governing the parties. Stop. Reference in this regard is made to the decision of the apex court in the case of Doli Rani and Doli Rani Supra, wherein the apex court has held as under quote unquote para 15 to 18 and para 35 to 37. Now next to reference is also made to the decision of the apex court in the case of S. Nithin and others, Supra, wherein the apex court in paragraph 14 has held as under, quote unquote. Reference is also made to the decision of the apex court in the case of Bhaurao Shankar Lokhande Supra, wherein the apex court has held as under, quote unquote, para 3, 4, 5, 12, 13. Apt also to, no, sorry, reference is also made to the decision of the apex court in the case of Priyabala Ghosh Supra, wherein the Supreme Court, wherein the apex court has held as under. Paragraph 16.
7, 9,
Paragraph 9,
10,
10,
and 17, and 25.
16, 17,
25.
25. Reference is also made to the decision of the apex, to the decision of the apex court in the case of Gopal Lal Supra, wherein para 5,
5 and
paragraph wherein the apex court has held as under, quote unquote, paragraph 5. Turning back to the facts of the case, it appears that PW6, who is, oh no, turning back to front, it appears that the prosecution has examined how many witnesses?
9.
9 with PW witnesses before the trial court. Stop. PW6, who is the priest who has claimed to perform the marriage of the accused with the accused petitioner with another
Arati Nath.
with another lady. Being the crucial evidence in the instant case, comma, his evidence is otherwise not available in English, right? It is in vernacular.
Lord, yes,
Um, i-
English or something.
is dealt with. Is dealt at the is being dealt at the outset. Stop. It appears that PW6 deposed that on 6/2/2000, the accused married one Aroti Nath in Pagletic temple by identifying himself as Bhubaneswar Nath.
Yes.
He further deposed that at the time of marriage, no, he further deposed that the marriage was performed as per Vedic rites. He further exhibited one marriage certificate being Exhibit 2. During cross, he stated that the marriage was performed in his temple as per, what is the word?
Veda,
Huh?
as per Veda.
In cross,
Yes, as Ved
As-
mote hoy.
as per,
Veda.
Veda.
Yajurba bed.
as per,
Yajurba bed.
No, my lord, he said Ved mote hoy. যজুর্বেদের রচয়িতার বিষয়ে নাজানো
Jajur bed mote hoy.
বিয়া যজুর বেদ মতে হয়। As per,
Yajurba bed.
what is the, how do you
There are
spell?
four Ved, Rig Ved, Yajur Ved. He said as per
Why?
Yajur.
Spelling.
Y-U.
As per so and so, Veda.
Veda.
Veda. Stop. It appears that PW1 who is the complainant, has deposed that she was married to the accused on 28/1/1993,
Spelling to study.
which has been also admitted by the accused while deposing as DW1. It appears that PW1 has further deposed that on 6/2/2000, the accused married for the second time with Aroti Nath at Pagletic temple. It further appears that PW2 deposed that deposed that the accused and Aroti Nath are living together and they have one son. It further appears that PW3, PW6, and PW3, who are the other one? PW3 and
Seven.
Seven.
PW7
Yes.
has also stated that, has also deposed that accused has married RT Nut in has remarried another girl without divorcing his first wife, PW1. Stop. It appears that the defense has examined 3 witnesses, including RT Nut,
Yes, Lordship.
including RT Nut
SDW3,
SPW3,
DW3.
DW3, who deposed that she gave birth to one male child
DW3
at Gwalpara Civil Hospital and
Same one.
I don't know.
and
37.
the accused is the father of her child. Correct.
Sure.
It appears that the trial court, after examining the evidence, opined that in view of the categorical statement of the priest that marriage was performed as per Vedic rites, it will be presumed that the essential rites was performed. Accordingly, the trial court convicted the accused. It appears that the appellate court also, after appreciating the evidence, no, it appears the appellate court, it appears that the appellate court has upheld the judgment and order of the trial court by dismissing the appeal. Relevant portion of the appellate court's judgment and order is reproduced hereunder for ready reference. Paragraph 8. 9, 10, quote unquote. Reading of the judgment and order of the appellate court, it appears that the appellate court, by referring to the judgment of Gopal Lal Supra, held that the second marriage in question was a valid one in the sense that the necessary ceremonies required by law or by custom have been actually performed. As discussed above, it appears that except the deposition of the PW6, who is the priest who claims to have conducted the marriage of the accused with ROT Nut, state deposition that the marriage was performed as per Vedic rites. There is no evidence whatsoever available on record to indicate that the essential marriage ceremonies have been performed. In fact, the 4 witnesses, Himakesh Das, Jibon Das, Bonomali Nath, Ratnankar Das, who appears to have been witness to the marriage, to the second marriage in question, as per the marriage certificate exhibited by the PW6 as Exhibit 2, were neither produced as listed witness nor as prosecution witness during the trial. The defectum of the essential Vedic rites having been performed, being one of the most vital piece of evidence, appears to have been not proved or established by the prosecution witnesses. On the contrary, the aforesaid four witnesses, if brought on record, could have certainly brought to light as whether these essential Vedic rites, essential ceremonies, as required as required under the Vedic, under the Veda,
Hindu law.
under the Hindu law, was performed or not. Not produced, non-production of the aforesaid witness, comma, in the event of non-production of the aforesaid witnesses, who appears to be most vital witnesses, comma, an adverse inference can be drawn against the prosecution. Paragraph
19-20.
But where have they said that it will become fatal?
There
I
are
wanted
20, my lord. Your lordship, see 7 lines. In other words, para 20, my lord.
Yes, I have seen 20. In other words,
In other words,
non-examination
non-examination, any of the ladies who accompanied the deceased to the cinema in
were
presence
all
of
vital to
vital.
the prosecution. All these were important omissions. But there are decisions more on this point, which says it will be fatal.
Go through.
Next. Viewed from the aforesaid angle, it appears that the judgment and order of the appellate court is patently and manifestly erroneous on the face of the record, and therefore cannot stand the scrutiny of law, cannot stand in the eye of law. Stop. That being so, I am of the unhesitant view that the appellate court as well as the trial court has committed manifest and patent error, and the findings are totally perverse without being based on any evidence of the second marriage being performed by following the essential ceremonies. Hence, the so and so of the appellate code as well as trial code is set aside and quashed, revision allowed, disposed of.
Accused may be acquitted, my lord.
Resultantly, the accused stands acquitted. Is he in jail?
No, he's on
Any
bail.
bail bonds given?
Yes,
And
sentence has been suspended by an IA.
the bail bonds discharged. Mr. Nath, every
Yes,
day is another day in this profession.
my lord.
Not necessarily a view taken will stick to the last.
Grateful.
Applies.
Yes. एक नहीं ले लो। एक नहीं ले लो। आर লগত থৈ দিব। লগত দি দিয়ক।
Please, your lord.
Yes.
My lord, this is quashing application, my lord. The for quashing of my lord complaint proceedings in complaint case number 122 of 2017, my lord. The complaint, my lord, is in page 15. Now, my lord,
Page?
15, annex 3, my lord.
Yes.
My lord, one KTC bonded warehouse, as a complainant, that a complaint has been filed against Zunbeli Dhaba, then I am number 2, my lord. Kamal
Kamal
Sharma.
Sharma.
Yes, my lord. And number 3, Sima Sharma. Sima Sharma, as here it is stated as authorized signatory of Zunbeli Dhaba. Now, my lord, while filing this complaint, my lord, that documents annexed with this complaint, as like the check, my lord, was not produced. My lord, I have filed for an affidavit, lordship
We'll
down
come
below
to
of the
all that.
file.
We'll come to all that, but
Yes.
first let us see what is the matter.
Yes. Now, my lord, the
You read the complaint.
my lord,
This is 138.
Yes.
my lord, 138, my lord. My lord, I first wanted to show them, my lord, check who has issued the check, my lord.
See, first let's
Yes.
read the complaint.
My
Let me have a grip of the matter. You
Definitely.
submit
My lord,
after
my lord.
showing the facts. Let us know the facts first.
Yes,
That is your defense.
my lord. My lord, they say, my lord, page 16, para 1, my lord, that the complaint is a company incorporated under companies in 1956, having a sophisticated KCC Road, Satribari, Mahendra Singh Building, ground floor, so and so, my lord, Guwahati, Polram Bazaar. And the aforesaid company is a bonded warehouse dealing in supply IMFL. The accused number 1 is a business firm under the name and style of Zunbeli Dhaba, represented by 1, Mr. Kamal Sharma, accused number 2. And while the accused number 3, namely Sima Sharma, is one of the authorized signatory of the Zunbeli Dhaba. The accused and the complainant has a business relationship, and during the course of business transaction, the accused had accrued some liability of 8,94,787 towards the complainant. The instant complaint is preferred by the attorney holder, come manager, say, Sukumar Saprobo. Now,
You are number 3, not Sima.
Sima, she has issued the malad check.
But you are appearing for Sima.
No, I am not, madam. This has been filed by the
You are for
Kamal Sharma, madam.
only 2.
Yes, madam.
You are only appearing
Yes,
for
yes.
2.
Madam.
Yes.
Malot, next para, Malot. The accused number 3, Sima Sharma, authorized signatory of Zunbeli Dhaba, had issued the check number 0005 dated 9/1/2017 for an amount of rupees 8,94,787 only drawn on the HDFC Bank Dhaka Complex Station Road near DRY Fish Market, Jagi Road in the district of Morigao, Assam for discharging their liabilities which the accused had incurred earlier from the complaint. That on receipt of the aforesaid check, the complainant presented the check to his banker, Axis Bank Limited, Panbazar, Guwahati in the district, Kamrup Metro, Assam, on 10/1/2017. They have not deposited. As per the advice, they give, but the said,
So your
Check
case is
was-
that the check was issued by accused 3, not
yes,
by you.
and I am no way connected with the Zunbeli Dhaba Mal. Malot, I have produced the Malot document that Chima Sharma is the Malot proprietor of the Dhaba. In the affidavit, I have Malot placed it. Malot, I am no
Where
way,
is the trial court's order?
Malot, that cognizance has been taken at the stage,
Acha,
I
it
came,
is at the
is
cognizance stage.
26.
Cognizance.
Page 26, Malot.
Hmm.
Cognizance taken. At this stage, I came, Malot, and the honorable court, Malot. However, suspended the Malot.
This is 2017 and there is a stay.
Yes, Malot. Yes. Now, Malot, they have,
No, but Seema Sharma and only Seema Sharma has filed.
Malot, yes, this can be filed against the Junbeli Dhaba as well
No,
as
no,
Sima
no,
Sharma.
no, no. This petition has been filed only by Seema Sharma, right?
Now,
Now
complaint
here-
has been filed by Malot.
Sorry, Kamal
KDC
Sharma.
KDC
Sorry, Kamal Sharma. Now,
petition.
but there is no complaint filed. There is no quashing filed by Junbeli Dhaba
Right.
or Seema Sharma.
Yes.
Now, then why there is a stay operating to the whole case?
Malot.
We were subsequently engaged in this.
Malot, by order dated 10/12, Malot. CR case was presently pending before Lanet case remains suspended. Malot, this was the order. 10/12/2018.
Yes, what do you have to say to this? Because this is the short point. Because
Yes.
Yes.
I am,
perhaps
yes, Malot. I am
no
not
case is
responsible
made
for
out
the
against
company.
Seema, against Kamal Sharma, the petitioner here,
Yes,
because he's not signed it.
no,
Then
that does not matter, Lordship, as per the.
Yes. and I.
Yes.
Yes,
Lordship, the sum and substance of petitioner's case is that he was not the proprietor and
And
he
he's
did
not
not
the
issue the check,
signatory.
he did not sign the check. Now, if your Lordship kindly sees section 141 clause 2 of the Negotiable Instruments Act. The signatory does not necessarily have to be only person who has to be fastened with this liability.
yes.
Lordship, 141, the head note says offenses by companies, but if your Lordship kindly sees the explanation, it covers all the firms and everything. Companies includes firms, individuals,
proviso is
association,
there.
yes.
Yes, but
May I read the relevant portions, Lordship. 141 clause 2. It starts with a non-obstante clause, notwithstanding anything contained in subsection 1, where any offense under this act has been committed by a company, which also includes the other firms and associations, and it is proved that the offense has been committed with the consent or connivance of, or is attributable to, any neglect on any part of any director, manager, secretary, or other officer of the company. Such director, manager, secretary, or other officer shall also be deemed to be guilty of that offense and shall be liable to be proceeded against and punished accordingly.
constructive liability.
Absolutely, Lordship. So does not matter that the
Where is
signatory.
that? Which document you wanted to show that?
Miles.
But that
Malot-
is a document.
In
Has
the
that-
court, Malot, they have exhibited allowing the evidence, Malot.
They
Their
have.
document.
The check.
Yes.
Which one?
Check, Malot. Malot, in the affidavit, Lordship, in the down the Malot file, Malot,
Yes.
page 5, Malot.
Yes, this is the check.
Yes, Malot. Page 5, Malot. For Zunbeli Dhaba, Lordship kindly mark it, Malot. For Zunbeli
For
Dhaba, that has
Junbeli
been
Dhaba.
signed by Seema Sharma, Malot.
Seema Sharma. Yes.
Yes, Malot.
Yes.
And Malot, so far the Junbeli Dhaba is concerned, Malot. Seema Sharma is the proprietor. It is an Assam space.
This is a government document.
Yes, Malot. Page 7, I have the type copy, Malot.
Page 6.
Yes. Yes.
Yes.
As per the provisions of Assam
2018.
Panchayat,
Huh?
its license is
Dated-
granted in favor of Seema Sharma. She is the proprietor, Malot, Junbeli Dhaba. So person who is actively my lord monitoring who is responsible is the person, she is the person in search, my lord. I am not. I am not connected with any business activity of this dhaba, my lord.
This
So
is
they are-
12/11/2018. Check is of 9/1/2017.
That's correct, my lord.
You
But
see, no, Mr. Sharma, the case is at a very initial stage. Yes,
Right.
you have a point. In that case, you can be discharged at an appropriate stage. Now you have come before this court and obtained a stay
my lord.
of a complaint of 2017. You have not allowed the complaint to proceed.
My lord,
Now, if this document is correct
yes,
and you have nothing to do with Junveli Dhaba,
my lord,
then of course there is no materials to proceed against you.
my lord.
No offense can be registered against you. But
Lord.
that stage has not come.
My lord, that has been done, my lord, in my humble submission.
How?
My lord, page 26.
Correct, but
Page 20, my lord,
at page 26, there is no document of 2000. The fact that you are not connected,
my lord.
that material is not before the court.
And moreover, my lord, on the
You have to
premises,
bring it
on the
at the
premise,
stage, appropriate stage.
my lord, even if that document is not looked into, my lord, from
Because you see,
from
Mr.
the
Sharma, I would have taken cognizance of this document.
Das, my lord, sorry.
I'm sorry. I get very confused with the surname. Mr. Das,
My lord,
Mr. B. Das.
my lord,
I would have taken cognizance of this document because it's a government document.
my lord.
But here the date is after the after the check was signed.
My lord.
Now we don't know at that date whether this was a proprietor firm or it was a partnership firm. We don't
My lord,
know.
only three judgments I want to place, my
But
lord.
we don't know that.
My lord, on this point, because my whole argument is that, my lord, without looking into the other documents,
Where can the other documents
my
be
lord,
looked
only the
into?
documents is that, my lord, the check which they want to enforce.
Yes.
My lord, the check which they want to
Where is the
enforce.
stage for looking into other documents come?
No,
When can the other documents be looked? Of course, if a document is absolutely admitted document, that can be looked into. There was no difficulty of taking this document on record. But this document is after the date of the check.
no, madam, I am saying, my lord, my submission is that, my
Where
lord,
is the document to show that in the year 2017, this was running as a proprietorship firm?
my lord, so far that stand is concerned, my lord.
You show me that document, I will quash it against you right away.
Yes, my lord. So far, I am concerned why they have put me, my lord, as a, my lord.
Not that. Where is the document to show that Junbeli Dhaba was a proprietorship firm at September 2017? Because you see, ultimately, it's a criminal proceeding, right? The court cannot just quash it on the basis of this annexure 2. Of course, I could have, provided the check was after this.
And
Then it would have been absolutely clear that you are not connected to Junbeli Dhaba.
my lord. And moreover, my lord, even my lord, that so far the other
Now,
cases are
what is
concerned.
now,
Yes,
now just tell me one thing. What is the law as far as proprietorship firm is concerned?
yes,
Because that section 141 is of companies.
yes, yes,
Company is a juristic person.
yes.
What about proprietorship or partnership firm? Whether that same thing will apply?
Yes. I am not even the partner of Junbeli Tower.
Assuming,
Assuming, yes.
assuming
It appears, my lord, that for one purpose of 141,
will apply.
the company and my lord, the proprietorship will also
Will
come
also
in. Now, my lord, in a case, my lord,
No, but there is
In
no evidence right now.
every person may not be there in the complaint because to
That's
honor the
okay.
check, my lord,
That's all right. It's at an initial stage.
for my
It
lord,
is at an initial stage. If you have nothing to do, you can be discharged.
but my lord, some judgments are there, my lord, it will be travesty of judgment, my lord, justice.
Travesty of justice.
If this person, for my lord, no fault of him is
How do
only,
we know at this stage that he is not he has no
my
fault?
lord, drawer of the check is before the honorable court. my lord.
Yes, lawyer is there, but it's a farm. You are only saying company that 141 would apply. You can have a case provided you have nothing to do with this Junbeli Dhaba. 2018 shows, yes, from 2018 onwards, you have nothing to do.
my lord,
But that itself cannot discredit the check which was issued at that time. We don't know the status of Junbeli Dhaba
my lord.
as on 9/2017. I'll resume in 5 minutes.
My-
You think about it.
Yes, I. War of the check was before, no? What was this? You were referring to section, no? 141? 140. What is that? He will reply to the aforesaid notice through his advocate White later dated 15 to 2017, wherein he denied that he does not have, he denied that he does not have any legal enforceable debt towards the complaint. Further, in this letter, it is also denied that he has ever issued the check number so and so, HDFC Bank branch. And it is also denied that there is no authorized signatory by the name of Sima Sharma. Furthermore, in clause 4 of the reply in legal notice, it is stated that Sima Sharma and my client both are separate entities having no business relationship at all whatsoever, what if with each other. My client never had any sort of business relationship with Sima Sharma at any point of time. Hence, the question of in cause of action arising against my client does not arise at all. Thus, the accused number 2, in his reply to the legal notice sent through his advocate, denied that he has never incurred in liability towards the complaint company. And my lord, this is in the my lord, evidence also they submitted before the court below, my lord, para 7. My lord, same thing. My lord, now, so far I am concerned, my lord, what has been, my lord, in the earlier order on 10/12/2018, while issuing notice, my lord, staying granting stay, lordship considered my that agreement, my lord, actually page 10 of the complaint. This is the, my lord,
1 second, 1 second.
license.
Yes, what were you saying?
My lord, page 10 is the, my lord, license, my lord, in my favor under IMFL on license.
Yes.
This is issued to Kamal Sharma. This is my license, my lord. My lord, due to my ill health, my lord, page 12 is the agreement between Kiran Gogoi and Kamal Sharma, my lord, to run this, my lord, to you.
Use the
Yes, my lord,
license.
license for his purpose with the condition that he will pay 15,000 per month. Para 3 and para 6 is important, page 13, my lord.
Yes.
Para 6, my lord, that profit or loss of MS Kirbar at Paschim Gaon in the premises Junbeli Dhaba complex shall be on the second party. Second party, Kiran Gogoi, I am told, is the husband of my lord, Sima Sharma. My lord, so far the liability, I have no liability with the accounts of the Junbeli Dhaba, my lord. This was considered in the while passing the first order, my lord. And this is
While
of dated
passing the-
16th of February,
While passing the
my lord, while considering the initial stay order, my lord. My lord, page 12, that agreement is dated 16 February 2015, my lord. My lord, in my humble submission, my lord, this document agreement amply signifies that I do not have a control over the, my lord, or day-to-day affairs of the Junbeli Dhaba. I am concerned with the rent 15,000, my lord. Now, my lord, although my version in the reply of their notice that was placed before the honorable court, my lord, court below, but then
you have missed out one vital paragraph,
my lord,
page 12.
my lord, sorry,
Whereas the first party, clause 3, where not it is not numbered, whereas
yes,
paragraph 4 from top.
my lord.
Whereas the first party, read.
Who is the first party here to having a license in his name for doing liquor business and is carrying on the sale business under the name and style of Hirbar at Quashing, Nagaon in the premises of Zunbeli Dhaba complex. Malot, yes, Malot. Malot, that check is of 2017. Before 2017, 2 years, in 2015,
Mr.
liability was not.
Mr. Das, these are matters which cannot be looked into by this court at the stage of quashing of the FIR or complaint.
Understand, but Malot,
How can this court go into all this?
I pray for Malot once again. Malot, let us see Malot 141. Malot, he has read 141 too. Malot 141 first one. Malot, kindly see Malot.
Yes,
If the person committing an offense under section 138 is a company, every person who at the time of offense was committed was in charge of and was responsible to the company for the conduct of the business of the company, as well as the company shall be deemed to be guilty of the offense and shall be liable to be proceeded against the punished accordingly, madam. Was responsible to the accounts and business and in charge, my lord. Now, on this basis, my lord, only 3 judgments I will place, my lord. I was neither a, my lord, in view of this, my lord, agreement, my lord, it suffice that I was not the person concerned and I was not,
this agreement is your document.
Yes,
my lord.
Is yet to be proved.
yet to be adduced before the
Uh,
court.
My lord, but while considering this revision jurisdiction, my lord, to
Not
save the
revision.
abuse of process of
Not
the court,
revision.
my lord.
This is revision.
Yes, my lord.
This is criminal
Quashing.
petition.
First,
Quashing.
482, my lord.
Where
My lord,
revision?
there is a judgment on Muhammad Wazid and others that I will place, my lord.
Yes.
There it is stated, my lord, these documents can be looked into, my lord, for ends of justice.
I think there is a caveat also in that judgment
Uh,
at the
Here
last
to the-
paragraph.
it will,
See the last paragraph?
my lord, the concerned paragraph I was referring.
Give.
This is in,
Which year?
my lord, 2000, AIR 2023 SC
Towards the last, just
3784.
read the last paragraph.
My lord, this is the, at
Last
least.
paragraph. If I am thinking it's the same one,
My
last
lord.
paragraph. Yes, read.
My lord. If needed, it would be with a due care and circumspection to try to reach in between the lines. The court, while exercising its jurisdiction under
Last
482,
paragraph.
my lord, take for instances the case on hand. Multiple affairs have been registered over a period of time.
Not all that, towards the end.
My lord. My lord, actually, I have the relevant one, my
Ah,
lord. Sir.
How can it be?
My lord, sorry.
You're not having the main. It will Dioxin decision too.
It was 2000, AI 2023. No, এটা ওলাব লাগিব. Sorry,
It will incomplete.
sorry.
Mr. Das, you should be on
I-
complete.
I was
judgment.
my
You
lord, just
cannot-
in the morning, my lord.
You cannot be just giving only the relevant pages of a judgment.
Next time, my lord.
Not expected of you.
Definitely. My lord, now from these judgments, my lord.
Yes.
Now first I will be referring 2010 TSSC 330.
Yes.
Harmit Singh, my lord, National Small Industry Corporation Limited versus Harmit
Yes.
Singh. Here, para 39 is directly on the point, my lord. By summarizing so many judgments, my lord, from the above discussion, the following principle emerges. The primary responsibility is on the complainant to make specific improvements as are required under the law in the complaint so as to make the accused vigorously liable. For frustrating the criminal liability, there is no presumption that every director knows about the transaction. Section 141 does not make all the directors liable for the offense. The criminal liability can be fastened only on those who, at the time of commission of the offense, were in charge of and were responsible for the conduct of the business of the company. Vicarious liability can be inferred against a company registered or incorporated under the company 1956 only if requisite statements which are required to be avoided in the complaint petition are made so as to make the accused therein vicariously liable for the offense committed by the company, along with the affirmance in the petition containing that the accused were insurers of the responsible for the business of the company by virtue of their position, they are liable to be proceeded with. Vicarious liability on the part of the person must be pleaded and proved and not inferred. If the accused is the managing director or the joint managing director, then it is not necessary to make specific averment in the complaint, and by virtue of their position, they are liable to be proceeded with. If accused is the director or a officer of a company who signs the check on behalf of the company, then also it is not necessary to make specific averments in the complaint. The person who sought to be made liable should be in charge and responsible for the conduct of a business of the company at the relevant time. This has to be averted. As a fact, there is no deemed liability of a director in such cases. Malot, person responsibility or the inserts, that has to be malot considered while issuance of such process, malot. Next judgment I was referring, malot. Harshindra Kumar, 2011 3 SSC, malot, 351.
Yes. Which
Malot
one?
here, Lordship may mark the para,
Which one?
malot, 10, 17 and
Which one?
27.
Which one? 2000?
Malot, 2011, malot.
Yes. Paragraph?
Paragraph 10, 17 and 27, malot.
Yes.
10, malot. Prior to 10, malot, 141 section was quoted, malot,
Yes,
10, malot,
10.
10. The legal position concerning the vicarious liability of a director in a company which is being prosecuted for the offense under section 138 of the NI Act has come up for consideration before the court on more than one occasion in SMS Pharmaceutical versus Nita Wala. The following questions were referred to a three-judge bench for determination. Whether for purpose of section 141 negotiable instrument 1881, it is sufficient if the substance of the allegation read as a whole fulfill the requirements of the said section, and it is not necessary to specifically state in the complaint that the person accused was in charge of or responsible for the conduct of the business of the company. Number B, where a director of a company would be deemed to be in charge of and responsible to the company for the conduct of business of the company.
Same point, it relies on that hermit.
Yes,
Singh.
Mala. Now, Mala, the point has been answered in yes, correct. Lordship is correct. Para 11, Mala, that has been answered. Mala, from this, I was drawing your Lordship's attention to their para 5 in their complaint petition and the evidence in para 11. They have stated, I negated, I have replied that I am not the person concerned. So that was not taken into account by the court below. Otherwise, for enforcing the same, the Junbeli Dhaba as well as the drawer of the SEC was before the court.
At the time of cognizance,
Yes.
a statement of the complainant was there.
Yes,
Where is that statement?
the para 5, Mala.
No. That is the complaint.
Complaint. Yeah, and the Mala evidence, Lordship para 11.
Para?
Mala, just I'm giving the page,
Page.
Mala. Page 24, para 7. I'm sorry, not 11, 7. Page
Yes.
24, Malone.
Yes.
Para 7, Malone. That after the receipt of the notice dated 23/1/2017, the accused number 2, Komal Sharma, gave a reply to the aforesaid notice through his advocate, while later dated
The
50.
same, it's the reiteration.
Yes. However, this is the evidence, my lord. My version was before the court below, my lord. They could have considered this. What is my connection? But that last judgment, my lord, is also same, my lord. SMS pharmaceuticals, that was also already considered. My lord, here para 19.
Any other evidence? Only one.
my lord.
Only one evidence or any other evidence?
At this stage, my lord, and most vital evidence is the, my lord, check, my lord. On behalf of Junbeli
Yes.
Dhaba by Sima sir.
May I submit now? So Lordship, there are much more aspects to this. If your Lordship may, so this substance is very simple that we were not at the helm of affairs. We are not the petitioner. We did not issue the check.
Not
Now-
now the fair, plus they are nothing to do with.
Nothing to
Junbeli.
do with, yes. So now Lordship, we'll see page number 8, the annexure 3,
Page number.
page number 8 of the additional affidavit. So this is annexure 3, the additional affidavit. This happens to be the notice that we had issued after the check was dishonored. That's for section 138 of Negotiable Instruments Act.
Yes.
The Lordship will see the notice has been addressed to Mr. Kamal Sharma, as
Proprietor.
proprietor of Junbeli Dhaba, in the address of Junbeli Dhaba. This is the address of Junbeli Dhaba. Now, if this person, the petitioner had nothing to do with the affairs or was not at all related, why did he accept the notice at the address of Junbeli Dhaba, point number 1?
The answer is in that license.
Yes.
I'll
agreement.
go further, Lordship. There's more.
He is doing his business in that premises.
But he entered
See,
into an agreement.
No, the argument which is coming from the other side is that your complaint is bereft of any material particulars as regards the role of accused number 2. You have simply said in the notice you have shown him as a proprietor. In the complaint you have said he's a proprietor. In your evidence you have not even said that he is the proprietor.
I believe
In evidence there is no
there is a
nothing
mention.
saying in the evidence you are simply saying he's the Junbeli Dhaba is represented
Yes.
by Kamal Sharma.
No document, nothing, my lord.
Have you seen?
if your Lordship will see the-
Represented by
no, Lordship. If your Lordship will kindly see page 22 of the evidence on affidavit. We've arrayed the accused number 2, the petitioner, as the party,
page 22.
page 22.
Yes, please.
Mr. Kamal Sharma, proprietor of Junbeli Dhaba.
No, where? Page?
Page 22, annexure 4. Annexure 4,
Yes, yes, but
the evidence on affidavit.
no, that you have said in the, you see, that is where I'm
This is-
saying. You have said in 2. Evidence, this is the complaint, this,
This is the evidence on affidavit, Lordship.
yes, but where have you said proprietor? Number 2,
Yeah.
you're
accused
you're
number-
referring to the cost title.
Yes.
How can that be?
I'll go further, Lordship.
That
I'll
is
go
the
further.
cost title.
Yes, that's the
Cost
cost
title
title.
is not evidence. Cost title of the complaint case.
Yes.
But in the evidence, where have you said he is the proprietor? Correct me if I'm wrong. I
If
have
your
read
Lordship may
it.
give me a minute, I'll just
Yes,
go
yes,
browse
please,
through.
please. Where have you said he's a proprietor? Paragraph 3. Accused number 1 is a business
Represented.
firm under the name and style of Junbeli Dhaba,
Yes,
represented by one Mr. Kamal Sharma.
that is accused number 2. There is no specific element to that end that he is the
Yes.
proprietor. All right, Lordship.
That
Just
is not there. When it was more required that you had specific averments as who is he? What is his connection to Junbeli Dhaba? And if he is one of the partner, whether he is in charge, whether he knows.
I have a judgment, Lordship, in this
All
regard.
right, I'll come to your judgment, but you have only brought 141 into the notice of
Yes.
this court.
Yes.
Now, in order to 141 to be attracted, those decisions of the apex court has to be also kept in mind.
Yes.
Mere saying he's proprietor will also not do,
Yes.
isn't it? Mere saying he's a partner will not do.
Yes.
Mere saying he's a representative of Junbeli Dhaba will not do. There have to be more averments, more in the complaint
Rightly, sir. Rightly, sir.
that
Okay.
he is because why I'm saying that, because he is not the holder. Sorry, he is not the signatory of the check. He is not the signatory. Admittedly, signatory is someone else. And he has brought one government document which indicates that that particular signatory is the proprietor of Junbeli Dhaba.
Subsequently.
Whatever.
What?
Whatever.
Subsequently.
There
Because
is
prior
nothing-
to that, there is an agreement.
No, that agreement doesn't say that he is the proprietor or has anything to do with Junbeli Dhaba. It shows that he has a license IMFL license in the name of something else, and he is going to do business in the premises of Junveli Dhaba.
Now, Lordship,
Now,
my
just because of that, can you say that he is liable for this money which has been dishonored?
Lordship,
The
in my respectful
Mr. Counsel, I am indicating this so that you can, I'll give you time to reply. Appears that the complaint is short of
that I will agree.
material particulars.
That I will agree.
Yes, please.
Now, Lordship, if your Lordship may kindly see that since the notice was issued at the address of Junveli Dhaba, now the agreement that has been brought forth before this honorable court says that due to his ill health, he absolutely absolved himself from the liability, gave the license to somebody else, and then he was running the affairs. Now he received the notice. Not only did he receive the notice, he took the liberty to open the envelope. He also issued a reply. Now, Lordship,
Matter? How does it matter? How does all that matter?
but Lordship, that in that reply,
Is it sufficient for fastening criminal liability on the accused number 2? Merely because he opened it, he received it in Junbali Dhaba's premises?
but there is more, Lordship. There is more. If I
That
may
is not necessary. That is not
submit in
sufficient.
sequence
You
what has
need to
happened.
show where in the complaint or in the evidence you have said what is the role.
But Lordship, so far as proprietary concern is concerned, the proprietor and if it is a company or a partnership firm, I absolutely agree that company being a separate entity, you cannot fasten all the directors with that
For
liability.
proprietorship firm,
So
you have not shown any document showing he is the proprietor. You have merely said, on the contrary, he is armed with a document which shows that he is not the proprietor. Proprietor is accused number 3, the signatory to the check.
but Lordship, I have a judgment. I have a judgment by this.
And on that, and it appears that the trial court has not applied its mind.
Yes, ma'am.
Without application of mind, cognizance has been taken. Cognizance order is a serious order.
Ma'am.
Some application, I'm not saying a mini trial is to be conducted at the stage of
Right.
taking cognizance, but some application of mind has to be there. Where is the application of mind? He is not the, that is an admitted position. The moment he is not the signatory, what is the next question that has to come to the mind of the trial court before framing that whether he has any role to do or not? How will the trial court come to that finding? On what basis? On the basis of the allegation that is available in the complaint and the materials placed by the prosecution at that time.
Absolutely, Lordship.
In your evidence, you don't even speak about him as a proprietor.
That is there, Lordship. But if Lordship may
And
kindly
in
see
the
what
evidence, you describe this accused number 1 as a business firm. The
accused
word
number 1,
proprietorship is also not there in para 3. And you say he is represented by accused number 2.
yes.
Represented in what capacity? If it's a proprietorship firm, he doesn't have to represent, he's the proprietor.
Yes, he is the proprietor. Ipso facto.
You see,
he's the-
para 3 is not, it's bereft of any materials to indicate that accused number 2 has anything to do with this farm. You have not said it. I am taking it to be correct, whatever you have said in your evidence. But even if I take them to be correct in its face value, where is it showing that he has
Material.
anything to do?
But otherwise, Lordship, the law otherwise says even if I array the proprietary concern, let's say I array the company, then I have to specifically enunciate that this director played this role, this
Correct,
role.
correct.
So far as proprietary concern is concerned, it is one proprietor.
Now, no, but in
it-
paragraph 3, you are not, you yourself have not said it as a proprietor. You have said it in your evidence.
How
You're saying it's a
serious-
business farm.
Yes.
How do we know what business firm?
How vicarious
Specifically when there are documents, which documents cannot be challenged by you at this, because these are from government documents.
Yes.
You have not taken you have not filed an affidavit saying these documents are not genuine also, isn't it? You can't also do that. It's a document obtained from the government office.
Yes. Yes.
That document can certainly be looked into at this stage.
So, but Lordship will see he received the notice fine till that end. He issued a
Yes.
reply. In that reply, He has not even denied that he's not the proprietor, Lordship.
He has denied at
No,
the
he's
end.
not.
Lord,
Lordship,
to-
may kindly
no,
see the
To
camouflage.
this argument, my lord,
No,
had I
think-
not
May I be
given
allowed
it,
to submit,
Yes.
Lordship?
Had
One
I-
second, I went,
My lord.
I had
Lordship, may kindly
checked that
see,
notice.
page number 10 of the additional affidavit, annexure 4.
1 second before we go there.
So this happened prior to the filing of the complaint.
Page number?
Page number 10.
Page number 10.
Page number 10, annexure 4.
My reply.
Yes, this is the reply that has been issued by Mr. Kamal Sharma, the petitioner. There is not an iota of denial. Lordship,
10.
Yes, page
Yes,
10,
yes.
additional affidavit, annexure 4.
Read para 3, ABCD.
Yes, no denial.
3 and 4.
Yes.
Lordship,
Three
Lordship,
and
may
4,
allow
madam,
me,
para-
allow me to just submit.
Yes, yes,
Lordship,
yes, please.
let's say a notice is issued in my name, I being the proprietor of XYZ firm, and let's say I am not the proprietor of that firm. Ideally, the first thing that I have to come up with the reply is that I am not the proprietor of this firm. You're mistaken. This has to be issued to so and so person. But if your lordship will see how strategically the camouflaging has been done, there is not a single denial that I am not the proprietor of this firm. Otherwise, that would have sufficed. This stance was later on developed at this stage before this honorable court. And I've already given a judgment. I'm relying on a.
Not happily worded, but you cannot say that it cannot be discerned from these
Madam, yes.
statements because even in paragraph 1, it says my client so and so received. My client, the claim made by you against my client through this legal notice is not correct and proper. The present claim has been made by your client by way of fabricating and manipulating the facts for the sole purpose of not only to harass but also to so and so. That your is not maintainable, that my client does not have any legal enforceable debt towards your client, namely KDC so and so, and that being so, the question of issuing so and so does not arise, that have been wrongly informed.
Then 3C and
Then
3D.
the
madam.
check in question was neither signed by my client nor the same issued on his behalf as has been alleged by you. As has been alleged by you. So he's denied that. I like to inform you that no person by the name so and so is an authorized signatory of my client. Moreover, my client does not have any business connection with any person named so and so. And as such, the question of such so and so making any business deal on behalf of my client does not arise. He has said not happily,
Para 4, madam.
not happily. The
there has
above
to be
facts make it
denial.
abundantly clear that your client had mischievously and wrongly interpreted the actual facts before you and thereby wrongly putting the entire blame on my client, knowing well that the check in question was not issued by my client or authorized. On account of the above, the claim is not just and proper. Ms. So-and-so and my client both are separate entities. Both are separate entities having no business relationship at all with each other. My client never had any sort of business relationship with so-and-so. It's all there. Separate entities.
But lordship, may
Yes.
kindly see
Which
the-
is this decision you want to rely?
So lordship, firstly, I am relying on judgment Neelam Devi Bagadia versus Vimal Kumar Todi. This is a 2005 judgment.
Yes.
Lordship may kindly refer to paragraph 16. Otherwise, there are citations. Citation would be 2005 to GAU LR 600. Paragraph 16, there are other relevant paras also, but so far as this current issue is concerned, I am addressing paragraph 16. In the case at hand, Lordship has found it.
Yes.
In the case at hand, what is, however, of utmost importance to note is that the notices issued by the complainant firm in terms of section 138 of the NI Act, when the accused petitioner number 1 replied thereto, she nowhere contended that she was not in charge of or responsible for the conduct of the business of her said proprietary concern. And nor did she contend that she was wholly, that is not relevant. Lordship, this denial at least has to be there that I have nothing to do. It was a very camouflaged reply. And that is my submission all along, that very strategically he is trying to evade from his liability. I will refer to other paras also. If your lordship allows me to submit on other aspects of this matter as well, so that I can.
You see, there were specific environments that she was in charge, therefore it has to be denied. You have not said all that. You have simply said he's a proprietor. And he says that they are separate entities. He has nothing to do. That he have said.
But he has to
That's
come.
why I use the word not happily worded.
Yes, and
It
that
may
is
not, but you see that notice is ultimately drafted by a lawyer.
yes.
Why should
But
he
why so
suffer its
gray-worded, lordship?
consequence?
That is the whole point. When the matter becomes gray, then it becomes a matter of trial. That is my limited submission. Lordship,
No,
may
but-
also take note of the order
You
dated
see,
10.
Mr. Your name?
Y Kothari, lordship.
Kothari.
Yes,
Mr. Kothari, of course, you have a case against accused 3 and 1.
I do.
In fact, it's sad that since 17, that has not proceeded.
Yes.
Very sad. But against accused number 2,
Stay order, lordship. Lastly, please refer to the stay order 10/12/2018, lordship. The submissions on the basis
I've
of which.
seen that he is not the signatory.
No, lordship. The stay order paragraph, may I read the entire stay with the order?
Yes, please.
Heard Mr. Learned Counsel for the petitioner, by this application under section 482, the petitioner has paid for quashing of the proceedings under so and so, wherein the learned magistrate has taken cognizance. The petitioner is one of the accused, being the proprietor of Junbeli Dhaba, and Mr. Das, Learned Counsel for the petitioner, submits that prior to issuing the check in question, by an agreement dated 16/2/2015, due to his bad health, he had handed over the management of the said dhaba to one Shri Kiran Gogoi. Now, on the basis of this agreement,
In
That
the
was-
agreement, the petitioner is.
Not that Dhaba, my lord, that is.
but
Where is that agreement?
Yes,
Agreement is on record. He
Yes,
is
yes.
not said he's the proprietor. Kamal Sharma
page 12, my lord.
in the district, so he doesn't say himself to be as a proprietor here.
Never said, my lord.
in the complexes, so the Assam Excise Act
Doesn't
says-
say proprietor, because you see, it is mentioned he's the holder of that license.
Yes,
Each of the first party, second one, whereas the first party here too is having a license in his name for
Right.
doing liquor business and is carrying on the said business under the name and style of Kirbar
which is in the
Kirbar.
premises,
Yes.
lordship.
in at so and so in the premises of
Premises.
Junberi Dhaba complex. Now, just because he's doing this business in the Junbeli Dhaba complex doesn't make him proprietor of Junbeli Dhaba. His business is in the style of Kirbar, Mrs. Kirbar.
my lord.
And his consistent stand is that these two are different entities. He may be, it is not difficult to understand why, because the license appears to be in his name,
My lord.
which the Junbeli Dhaba is taking,
Right.
is utilizing it. It is obvious. Isn't it obvious?
It
It's
is
common
obvious. It is-
sense.
Yes, otherwise,
It is
had it
common
been,
sense.
lordship, had it been one averment in the complaint, the matter would have been at a different state right
Correct.
now.
That is not there.
That is not there.
That is not there. Now, because of that, how can a criminal prosecution be allowed to be continuing against
Lordship,
him
when I issue
when
notice to the,
admittedly he is not the signatory to the check?
then lordship, last judgment. If that I can satisfy your
Yes.
lordship, last judgment would
Yes.
be Mrinal Kumar Sharma versus Jain Agencies.
Yes.
Citation hai?
Citation is 2018 Supreme Guwahati 203.
Yes.
Lordship, I'm just coming to that. Page 4 of the said judgment, page 4. Lordship will see from paragraph, there's no paragraph, it's Roman numeral 2. N Vidyananthan Deepika Milk Marketing versus Dodla Daily Limited. Could your lordship find that particular, may I read the part, lordship?
Yes, please.
Section 138 of the Act contemplates that prosecution could be launched against the drawer. It is a settled position of law. that the
Sorry,
proprietorship-
where are you reading from, Mr.
Uh,
Kothari?
Page 4, lordship. This is page 4 of the judgment, Roman numeral 2.
Yes, yes.
Now, section 138 of the Act contemplates that prosecution could be launched against the drawer. It is a settled position of law that the proprietorship concerned by itself is not a legal entity apart from the proprietor. The proprietary concern and the proprietrix are one and the same person. To put it differently, the prosecution against the proprietrix representing proprietorship concern or proprietorship concern represented by proprietrix are one and the same, as both these things sync, sail, and merge with only entity. Now, yes, circumstantially, I'm trying to substantiate that I issued the notice or he received the notice. He stepped into the foot of the proprietary concern.
How can that be, Mr. Kothari? How can that be? Admittedly, the documents are suggesting otherwise. They are suggesting otherwise. 2018, that license, proprietor is accused number 2. Accused number 2 signs, it is written for so and so, for Junbeli Dhaba. He signs for Junbeli Dhaba.
Seema Sharma, if your lordship will see the check in
This case
question,
is of no assistance to you, Mr. Kothari.
I understand lordship, but Seema Sharma
It
seems
is
to be
in
the-
fact against you. There is nothing wrong. You go ahead with accused 2, 3. This court is not going to
uh,
quash it against that.
Absolutely, Lordship.
This court
Like, there's
is only concerned
we are
with
not-
accused 2.
But lordship, Seema Sharma is the authorized signatory as per the check on that relevant point of date. So there has to be some proprietor of Junbeli Dhaba, right, lordship?
That doesn't make him. That doesn't make him. There is no allegation. There is no averment to that effect. In your evidence, you have not even said he is the proprietor. That is your evidence.
Except for the cost title, which is not evident.
How can that
Yes,
cost title be an
yes.
evidence? You should have substantiated it. You have not done it.
Otherwise, his role, I have specified
No.
his role, but as
Where
proprietor,
you have specified
not as proprietor, but what he has been doing. If the lordship
what
is,
he's been doing.
yes,
Where is it? What he's been doing? What have you said?
lordship
not
will
said-
take note of.
During the course of business, you have simply said.
Yes, page 25.
Yes, read.
Nothing which mentions that he is the proprietor, but
Then-
then he says that he's been evading his liability and he has been actively
not-
trying to.
Not, there is no averment. Even if there was one averment, would have been sufficient.
Sufficient, yes.
That's not there.
But given this judgment, lordship, if I am arraying that
You
proprietary
are
concern,
simply arraying him as a proprietor is not sufficient.
sufficient.
In your evidence, you have not even said he's the proprietor. You have said business firm. In your evidence, you don't even disclose it as a proprietor firm. You have said it's a business firm represented by one so and so. In what capacity?
Considering the circumstances and his role and his evasive reply, and
That is not sufficient for taking cognizance against him. Criminal actions cannot be cannot be put to motion in such casual manner.
and otherwise the scheme of enact also to that end, 139 says that otherwise he'll get sufficient opportunity to discharge that.
No. Before going to that stage, there has to be sufficient material.
Some material, right?
Where are those materials? Sorry.
Even in the list of witnesses, lordship, I have mentioned the bank witnesses. The bank witnesses are mentioned. So even if I call the bank witnesses in the course of trial, they can at least
Complaint is bereft of any material
Yes.
as far as the accused is concerned.
But evidence, lordship, there is still scope of evidence. Like
If tomorrow something comes out, you can always do something. At this stage, there is nothing. Why should this court allow this cognizance against him?
fairly.
I am only interfering with the order. I'm not setting aside anything. Only the order of the cognizance. Cognizance could not have been taken against him.
And my lord, one submission, my lord, 2005 8 SCC, there, my lord, 19, para 19C, last line, my lord, if lordship may kindly see, my lord, if the drawer of the SEC, ultimately, my lord, the drawer of the SEC has been held responsible, my lord. 19C, my lord. It starts as so far as the signatory of a check which is dishonor is
Which
concerned,
one are you reading?
my lord, 2005 8 SCC.
Okay,
89,
there is something,
Nita Bala.
paragraphs are different.
Nita Bala. my lord.
Nita Bala or Neelam Devi?
Nita Bala,
No, it's not
2005. Sorry, I'm sorry. SMS Pharmaceuticals versus Nita Bala.
That,
SMS
that,
Pharmaceuticals.
that is a decision relied by you.
Yes. There, my lord. 2005, my lord.
Yes.
Para?
Para 19C, my lord. Last line, my lord, kindly see. Last line. So far, the signatory of a check which is dishonored is concerned, he is clearly responsible for the incriminating act and will be covered under subsection 2 of section 141. Well, signatory is there, my lord. And another, perhaps she is liable. This is responsible for the conduct of the business.
All right.
Deeply over.
Item number 1. Heard Mr. B.K. Das, learned counsel appearing for the petitioner. Stop. Also heard Mr. D.K. Kothari, learned counsel appearing for the respondent.
Only one sole
For the
respondent.
sole respondent. Stop. By way of this petition, under section 482 of the CRPC 1973, the petitioner is seeking quashing of the proceedings in CR case number 1220/2017 under section 138 of NI Act 1881, pending before the learned judicial magistrate first class Kamrup M at Guwahati, as well as the order dated 24/4/2017, whereby cognizance was taken against the petitioner as well as the other accused under section 138 of NI Act. So far the petitioner is concerned. Stop. The brief facts of the case is that the respondent filed a complaint case being complaint case number 1220 of 2017 before the jurisdictional judicial magistrate under section 138 of the Act of the said Act, alleging that that one Junbeli Dhaba, Jagi Road, the petitioner, and one Srimati Seema Sharma no. Again, don't say alleging, against the Junbeli Dhaba, Jagi Road petitioner and one Seema Sharma, alleging inter alia that Seema Sharma had issued a check amounting rupees 894,787 towards discharge of liability in favor of the respondent, and the said check was dishonored by the bank for the reason funds insufficient, and therefore the complaint case was filed.
Lordship, may I intervene? Extremely sorry. I believe I have not brought this to your Lordship's slide, page number 18 of the evidence on affidavit.
Page number?
Page number 18 of the complaint, Lordship.
Yes.
And page number 24 also of the evidence on affidavit.
Yes.
Page number 24, paragraph 6, Lordship.
84 is that referring to his reply?
No, page number 24, paragraph 6. I'm extremely sorry, Lordship. I could not bring this.
Paragraph?
Paragraph 6.
Hmm. Okay.
This in consonance with the order dated 10/12, where they submitted.
What did you write? The upon after invest you say that accordingly the jurisdictional police station was directed to investigate the matter, and upon the materials being placed before the jurisdictional judicial magistrate court, the magistrate court, upon perusing the complaint petition documents annexed to it and the initial deposition of the witnesses, was pleased to observe that sufficient materials was pleased to take cognizance against Junbeli Dhaba, petitioner, and Seema Sharma under section 138 of the negotiable instrument of the said act. Stop. Situated thus, the present quashing petition has been filed by the petitioner. Stop. Mr. Das, learned counsel for the petitioner, submits that though the petitioner has been referred as the proprietor of the Junbeli Dhaba, however, he is not the proprietor of the said dhaba. In fact, it is Seema so and so who is the proprietor of the said dhaba and the signatory to the check which was dishonored. He further submits that the complaint, apart from referring the petitioner as the proprietor of the said firm, does not contain any averments whatsoever as regards the role played by the petitioner. He accordingly submits that no cognizance ought to have been taken by the jurisdictional magistrate court against the petitioner on the basis of such complaint which falls short of material allegation against the accused, against the petitioner to constitute an offense under section 138 of the said act. In support of the aforesaid submissions, he relies upon the following decisions of the apex court. Number 1, SMS Pharmaceuticals Limited versus Nita Bhalla and another, reported in 2005, volume 8 SSC at page 89. Number 2, Harshendra Kumar D versus Ribati Lata Koloi, reported in 2011, volume 3 SSC at page 351. Number 3, National Small Industries Corporation Limited versus Harmeet Singh Paintal and another, reported in 2010, volume 3 SSC at page 330. Per contra, Mr. Kothari, learned counsel for the respondent, submits that it is clearly averred in the complaint that the petitioner is the proprietor of the Junbeli Dhaba, on behalf of which the Seema so-and-so had issued the check which was dishonored. He accordingly submits that under section 141 of the said act so-and-so, the petitioner is vicariously liable, and therefore the order of the magistrate taking cognizance against the petitioner under section 138 of the said act warrants no interference from this court at this stage. Don't say at this stage. He further submits that the complaint being at the case being at the cognizance tense and evidence and is yet to proceed further, any interference at this stage would scuttle the criminal investigation at the butt, and therefore stop. In reliance of the aforesaid submissions, in support of the aforesaid submissions, he relies upon the following decision of this court. Following decision of the coordinate bench of this court in the case of Mrinal Kumar Sharma versus Jain Agencies, reported in 2018, 0 Supreme within bracket Guwahati GAU 203. Please check all the party names properly. And Nilam Devi Bagaria versus Vimal Kumar Toti, reported in 2005, volume 2 GLR at page 600. I have given prudent considerations to the arguments advanced by both the learned counsel by the learned counsels appearing for the contending parties and have perused the materials available on record. Full stop. I have also considered the citation submitted at the bar. Apt to reproduce the complaint, which reads as hereunder, quote unquote, paragraph 1, which is at page 16, to paragraph 12, which is at page 20, and then to paragraph five, at page 18, page 18. And you say relevant portion of the complaint, apt to refer to the relevant portion of the complaint. In support of the aforesaid complaint, the complainant has filed its evidence on affidavit on 17/3/2017. Stop. Relevant paragraph of the aforesaid evidence on affidavit is also reproduced hereunder for ready reference. Paragraph 3, paragraph 4, paragraph 5, paragraph 6, quote unquote, page 23 onwards. Reading of the aforesaid complaint as well as the evidence of the complainant, it is apparent that the alleged case of the complainant is that one is that the Junbeli Dhaba during course of business transaction incurred some liability of rupees 894,787 towards against the complainant. It appears that accused number 3, who is alleged to be the authorized signatory of Junbeli Dhaba, had issued a check amounting to the aforesaid rupees, amounting to rupees so and so, that 894,787, in favor of the complainant for discharging their liabilities. For discharging the said liability. Stop. It appears that upon presentation of the aforesaid check, the same was dishonored, for which a notice was issued to the petitioner as well as the other, as well as to all the accused.
No, only to the
To the petitioner, describing him as the proprietor of the said dhaba. It appears that in para 3 of the evidence in affidavit, the said dhaba was described as a business firm represented by the petitioner. And Seema Sharma is described as one of the authorized signatory of the said dhaba. Based on the aforesaid materials, it appears that the magistrate court, by order dated 24/4/2017, has taken cognizance under section 138 of the said act against the petitioner and the said dhaba and Seema Sharma. Stop. Okay. After break. Yes.
May I please your lordship? Lordship, in item number 27, lordship, I need one accommodation, lordship, because lordship, arguing counsel Mr. R. Bora, lordship, he suddenly left the court because his mother is
27.
hospitalized, lordship.
27.
Lordship,
All right. You are for the petitioner.
lordship, I have already taken.
Okay. 27. Mr.
NK Sharma, lordship.
NK Sharma submits that due to sudden medical emergency in the family of the leading counsel, Mr. A.M. Bora, he had to leave.
R. Bora,
R. Bora, he has to leave the court premises and accordingly seeks accommodation in the matter. Prayer is allowed. Relist
lordship. One more court,
after 2 weeks they did. Yes.
highly obliged, lordship.
Could not reach them. The matter has been pending since long, lordship.
So what do you want?
We seek some time for this. We will
Some time for what?
try to contact and get instructions, whether they are surviving or not.
Oh, you are for?
I am for the petitioner.
Who's for the other side?
PP is there.
In item 15, Mr.
S.A. Bhakhtiar.
S.L.
S.A. Bhakhtiar.
S.
A. Bhakhtiar for
A.
N. Alam.
On behalf of
N. Alam.
and Alam submits that seeks accommodation in the revision petition on the ground that the matter being old, they have lost touch with the client and accordingly seek some accommodation.
Okay, so whether they are surviving or not, we will try to get instructions from them, proper instructions.
Accordingly, they to obtain instruction, you say 6 times to obtain instruction
there-
whether the petitioner is surviving or not.
Also, interim
as-
is there.
Huh?
Interim is there.
Prayer is allowed, relist after 2 weeks of the date deliver. Interim, if any, shall continue to the next date of listing.
Much surprise.
My lord, item number 17, same prayer, my lord.
Item number?
17, my lord. My lord, I have no contact at all, my lord, since 2012, my lord. My lord, same prayer, my lord. My lord, let it become after 3 weeks.
Only last chance because in
My
case
lord,
of-
my lord.
because these are revision petition, whether what is whether you're in touch or
Exactly,
not in
my
touch, this court will look into the order. If there is anything, this court will pass appropriate orders.
My lord,
and will
already I
dismiss
have
it.
written a letter, my lord.
17 also, right? You heard
A. Manna.
Mr. A. Manna, Learned Counsel for the petitioner seeks 2 weeks time to obtain instruction as whether the petitioner is surviving or not.
My lord,
Prayer is allowed, relist after 2 weeks on a date to be fixed by the registry. Yes.
oblige.
May I please, your lordship?
Mentioning R is over. Why everybody is mentioning at this time? Yes. What do you want?
Lordship, same prayer, my lord.
In respect of?
In respect of item number 11, my lordship.
In item number 11 also same thing. Your name?
H.J. Tamuli,
N.J. Tamuli. S.J. Tamuli.
lordship.
Okay.
Oblige.
Section 138, 139, and 141 of the said Act reads as hereunder, quote unquote 138, quote unquote 139, quote unquote 141. It appears that in the event a check is dishonored, proceedings under section 138 can be initiated after issuance of demand notice, after the holder of the after the drawer of the check fails to make the payment of the dishonored money to the payee after within 15 days of receipt of the demand notice. Stop. It appears that under section 139 of the said act, it shall be presumed, unless the contrary is proved, that the holder of a check received the check of the nature referred to in section 138 for the discharge of liability. It further appears that under section 141, in the event the person committing an offense under section 138 is a company, every person who at the time the offense was committed was in charge of and was responsible to the company for the conduct of the business of the company, as well as the company, shall be deemed to be guilty of the offense and shall be liable to be proceeded against. However, pertinent that the non-obstante clause, a non-obstante subsection, provides that in the event, provides that where any offense, provides that when the said offense is committed by a company and it is proved that the offense has been committed with the consent of or connivance or is attributable to any neglect on the part of any director, manager, secretary, or other officer, the said person shall also be deemed to be guilty of the offense and shall be liable to be proceeded against. So, the explanation to section 141 clarifies that company means any body corporate and includes a firm or other association of individuals. And director in relation to a firm means a partner in the firm. Is there any decision showing that a proprietorship firm can also be brought under this? Because you see, director, it says means a partner.
My lord.
Now here it's a proprietor.
My lord, what I understand, my lord, that the concept of vicarious liability, that concept comes from 141, my lord.
No, but what about
Yes.
proprietorship firm?
May I
Because,
submit to
because
that
you see,
effect?
proprietorship firm is only one person,
Yes.
Yes,
One and same.
yes,
one and same. If it is the name of the firm also, it is obvious
yes.
that it is the proprietor,
Yes.
isn't it?
My lord.
That is why in 1800s, the separate concept of companies came up in England to separate those entities.
Yes, but as far as Anna Act is concerned, here they say company shall also include body corporate, shall also include firm or other association of individuals.
Yes.
Whether a proprietorship is also covered or not. Maybe because the concept of proprietorship otherwise does not apply.
Yes.
Yes.
Where is the question of vicarious liability? It is
Yeah,
the
right, no question. No question.
proprietor alone.
Correct.
But we say proprietorship firm. So in that case, if we want to attribute connivance, let's say
Anyway, let me not get into
yes,
this
yes.
thing right now in this case. Then you write, huh? It appears that in order to attract 141 of the said act, necessary averments as regards to the role played by the person
In charge of business.
stroke officer is required to be made in the complaint stroke FIR, again the complaint itself. In the complaint, can you repeat? Can you read that sentence? Uh, 141, when an offense is alleged to have been committed by the company stroke firm with the connivance of the director stroke partner stroke partner, comma, specific averments attributing the role of such persons is to be made out in the complaint itself. In other words, the complaint should specifically spell out how and in what manner the partner, the director stroke partner was in charge of or was responsible to the company in question, to the accused company for conduct of its business. Hence, mere bold statement that no, don't say that. In then you say reference is made to paragraph 39 of the Apex Code decision in the case of National Small Industries Corporation Limited versus Harmeet Singh Paintal, reported in 2010, volume 3 SSC at page 330. Reference is also made where is that case? The other one is
My lord, 2005, 8 SCC, my lord, 89. SMS Pharmaceuticals Limited. my lord.
A reference is also made to the decision of the apex court in the case of SMS Pharmaceuticals Limited to paragraph 19C. Paragraph 19C of the decision of the apex court in the case of SMS Pharmaceuticals Limited versus Nita Bhalla, reported in 2005, volume 8 SSC at page 89.
And then, my lord, the 2011 3 SSC 351. my lord.
Reference is
Harshendra.
also made to paragraph 11, 10, 11, 17, and 27 of the decision of the apex court in the case of Harshendra Kumar D versus Rebatilata Kuloi, reported in 2011 3 SSC 351. Perusal of the aforesaid decisions, it is apparent that all quote unquote those paragraphs. It is apparent that essential averments indicating the role played by the person alleged to be in connivance with the accused company in order to fasten vicarious liability on such person ought to be contained in a complaint before a person can be subjected to criminal process. Therefore, in order to bring a case within section 141 of the Act, the complaint must disclose the necessary facts which make a person liable. It is necessary to specifically aver in a complaint that at the time the offense was committed, the person accused was in charge of and responsible for the conduct of business of the company. This averment is an essential requirement of section 141 and has to be made in a complaint. And unless made in a complaint, stop. Without this averment being made in a complaint, the requirement of section 141 cannot be said to be satisfied. Stop. In the present case, it appears that the complainant has described the petitioner as proprietor of the accused farm. It further appears that the check was issued by Seema Sharma, who is stated in the complaint to be an authorized signatory of the accused company. It further appears that the complainant has averred in the complaint that during the course of business with the accused company, a liability of rupees so and so there arose a liability of rupees so and so against the complainant. So, surprisingly, no averment in the complaint as regards the how and in what manner the petitioner was in charge of or was responsible to the accused company for conduct of its business is averred. Mere bald statement that he was the proprietor is not sufficient to draw the presumption under section 141, inasmuch as admittedly the check, inasmuch as the drawer of the check is not the petitioner. It further appears that pursuant to the demand notice issued by the petitioner, issued by the respondent, the petitioner filed its reply Where is the reply annexed?
In the one of the page 10 line. Page 10 onward. Annexure 4 of the additional affidavit.
In the additional affidavit, my lord, page 10, my lord.
Filed a reply on 15/2/2017, wherein the complainant, wherein the petitioner averred that the claim made by the complainant against wherein the counsel, wherein the advocate for the complainant, for the petitioner, averred that the claim made against the petitioner is not correct, and the same is made by way of fabricating and manipulating the facts. Stop. It is further averred in the said reply that the petitioner does not have any legal enforceable debt towards the complainant, and that being so, the question of issuing any check in favor of the complainant does not arise. It is further averred that no person in the name of Seema Sharma is an authorized signatory of the complainant, of the petitioner.
Yes.
And that the petitioner does not have any business connection with any person named Seema Sharma. And as such, the question of such Seema Sharma making any business deal on behalf of the petitioner does not arise. It further appears that the petitioner that the check in question was not issued by the petitioner, and Seema Sharma and the petitioner are both separate entities, having no business relationship with each other. Stop. It appears that where is that? It appears that by that the petitioner, by filing an additional affidavit on 10/6/2020, has brought the check in has brought a license issued by the Jagirat Gao Panchayat in favor of one Seema in favor of Seema Sharma, wherein she has been described as proprietor of the accused farm. Stop. It further appears that in the quashing petition, the petitioner has annexed a foreign liquor, a license for the retail vend of foreign liquor in a restaurant to be consumed on the premises dated 4/12/2010 in the name of the petitioner. It further appears that by agreement dated 16/2/2015 between the petitioner and one Kiran Gogoi, it was agreed that the petitioner, who is having a license in his name for doing liquor business and is carrying on the said business under the name and style Messrs. Kirbar, Kirbar, at Panchim Nagar in the premises of the accused Dhaba complex. At the premises of the accused farm.
Number one, madam. Accused number one.
Accused number one.
Yes.
Having, how did you start that sentence? Agreement dated so and so. Not agreed. It okay. Then comma intended due to acute health problems of the petitioner and run the affairs of Messrs. Kirbar. Appointed Kiran Gogoi to manage the functioning of Messrs. Kirbar. And accordingly, the agreement was executed. It appears that the check in question was issued by Seema Sharma, showing herself as authorized signatory for the accused dhaba, for the accused farm, the farm only. It further appears that in the evidence in chief, in the evidence on affidavit filed by the complainant before the Judicial Magistrate Court at the stage of filing the complaint described accused number 1 as a business firm represented by the petitioner. Paragraph 3 of the aforesaid evidence on affidavit is reproduced hereunder for ready reference, page 23. However, in the same evidence, at paragraph 6, the complainant deposed that one notice through his pleader was sent to the proprietor of Junbeli Dhaba, I, the petitioner, on 23/1/17. It appears that on the basis of the aforesaid materials collected by the prosecution, the Judicial Magistrate Court took cognizance under section 138 of the Act, said Act, against the petitioner as well as the accused firm and Seema Sharma. Stop. It is apparent that in the present case, except bald statement that the petitioner was the proprietor, comma, there is no averment as to the specific role of the petitioner in the complaint or in the materials collected by the prosecution. It appears that despite lack of such specific averment, the magistrate court took cognizance against the petitioner under section 138. That being so, the said cognizance under 138 of the said Act against the petitioner is patently and manifestly erroneous.
Not sustainable.
Erroneous. Stop. That and stop. Hence, the cognizance taken against the petitioner by order dated 24/4/2012 by the magistrate stands set aside and quashed so far the petitioner is concerned. Let the proceedings be continued against the other accused in accordance with law.
Also, just one thing, if possible, let's say we examine the bank witnesses in the course of trial, and through the bank witnesses, it is established that
always there.
that liberty may be given, otherwise this will become an impediment.
Decided out of full pleasure hearing. Obliged, my lord.
That liberty is always there, Mr.
Yes.
Kothari. Disposed of.
Deeply obliged, my lord.
Deeply opposed.
None appears for the petitioner on call. List after 2 weeks on a date to be fixed by the registry.
A.S. Tapada for the respondent. A.S. Tapada for the respondent. A.S. Tapada for the
Give his name.
A.S. Tapada.
A.S. Thapa.
Tapada.
That. More naam to likhiye young detail.
I'm obliged, man.
2 and 3, huh?
Kindly allow me to call my senior lordship.
Has he become free?
Yes, lordship.
None appears for the petitioner on call. Huh?
Lordship, I am appearing on behalf of S. Biswas, Legal Aid Council.
MS
D. Devi.
huh?
D. Devi.
D. Devi is present on behalf of Mr. S. Biswas, Learned Legal Aid Council,
Legal Aid Council.
for the respondent,
Respondent number 1.
for the respondent number 1, and
MP Goswami.
Mr. MP Goswami, Learned APP, for the state respondent is also present, and both together you say are present. It appears that this petition was listed today in the order column with a remark for dismissal, as on the last occasion, 13/3/2025, also there was no representation on behalf of the petitioner when the matter was called. In view of the consecutive non-appearance of the petitioner, non-appearance for the consecutive no representation on behalf of the petitioner, despite the matter being listed in the cause list with the remark for dismissal, comma, the petition stands dismissed for non-prosecution.
Amlay.
Where is the other side?
My lord, today the hearing part may not be possible, but we have filed an IA, my lord. If a lot.
Which is the IA?
Yes, my lord.
Number 38. 37. 376. 376.
3769 WPC. IA.
What is the relief that you are asking in the IA?
176, my lord.
Yes, what is the relief?
My lord, actually what had happened, this matter was at one point
For
of time, part hard,
continuation, interim
continuation,
order.
yeah. So it so happened, my lord, then subsequent date, I'll just show, my lord, if your lordship would kindly
But
come
where
to
are the
page.
respondents?
Sir, here. For example, if your lordship would kindly come to page number 17, my lord.
17.
Yes, 16 rather. Hearing remains inconclusive. Leaves the matter on 2 p.m.
Interim
on
orders
so and
will
so for
continue.
further hearing.
Yes.
Interim order pass till the next date of listing.
Yes.
But in the next date, my lord, somehow this order was not continued.
When is what is
The
the
2
next
dates,
page?
my lord,
When is
on
next page?
page 19, 110/24. Actually, since it was a part heard matter, release the matter on 3/10/24 for further hearing. A compilation of all relevant notifications, documents for assistance of the court have been provided, so and so. This on this date, it was not continued, and on another date, my lord, 3/10/24 at page.
But why it was not brought to the notice of the court?
Actually, my lord, we were also under the impression, my lord, that it is continuing. Subsequently, we got to know. That's why this IA has been filed. Normally, in a part-heard matter, and when it is hearing was going on.
Heard Mr. K.N. Chaudhary, Learned Senior Counsel, assisted by R. Katurti. Top. Also heard Mr.
A.K. Datta.
A.K.
Datta.
Mr. Gogoi, you are appearing. It appears that interim order by mistake has not been continued on
Yes.
dates. It was a part-heard matter. I can post it for hearing, but I am allowing the
Already
interim to continue.
Hearing is concluded, lordship. Hearing is concluded, lordship.
My lord, when hearing is concluded, my lord, when the question of,
What?
my lord, hearing is already concluded. On
That
to-
does it mean that the interim order will be vacated?
On this, my lord, the started advocate in the argued in the last occasion that it should be continued by.
No.
That is why, my lord.
No, this seems to be, nobody had pointed out also.
Exactly, my lord.
But
No, it was
hearing
pointed out,
is
lordship.
not set to be completed. It says some compilations was given by Mr.
It
Majumdar.
was given, my lord.
No. Hearing is
Written
completed.
arguments have been given.
Given, we are given. Both
So
sides.
we'll post it for hearing
Further hearing.
on Thursday,
Loss.
next Thursday.
Hearing is concluded, loss.
We'll post it on Thursday,
Loss.
Next Thursday, Milord.
next Thursday, and see what is to be done.
Loss.
If required, I'll pass the judgment in court.
Loss.
It appears that please take their slip. It appears that this interlocutory application has been filed for continuation of the interim order dated 30/7/2024, passed in the instant writ petition IWPC number 3769 of 2024, which was not continued in the last two orders.
Yes.
Stop. A perusal of the last two orders, I-26. No. A perusal of the order dated 26/9/2024, wherein after hearing this matter, since the hearing could not be concluded, the matter was fixed on 27/9/2024 for further hearings. It further appears that in the said order, interim order passed earlier was directed to continue till the next date of listing. It further appears that thereafter the matter was listed on 1/10/2024. However, the interim order passed earlier. However, there is no mention of continuing the interim order passed earlier. It further appears that the matter when last came on 3/10, last is 3/10?
Yes.
3/10/2024, on which date the parties had submitted written synopsis. In that, on that date also, there was no order for continuation of the interim order. It appears that due to oversight, the interim order passed earlier was not continued by the last two orders.
Otherwise, the pair was made.
It appears that the matter is part heard. It appears that in the main case, written arguments have also been submitted by the parties. That being so, in the interest of justice, I allow this interlocutory application by directing that the interim order passed earlier shall continue till the next date of listing. In the main case, you say, it appears that in the main case, you say the relist when Thursday. Thursday is convenient. Relist on Thursday.
Or if it is not inconvenient, Milord, could it be following Tuesday, Milord, instead of Thursday? Thursday will be 26th.
Then 25th, Tuesday.
20?
Tuesday.
On such and such date. You will have to refresh the memory of the court on
Yes,
that
yes, we'll
day.
do that.
Just refresh it,
Yes.
and I'll take it from there.
No, the first appeal,
First appeal.
27
Mr. Gogoi,
27 go.
Mr. Chaudhary, Mr.
27.
Gogoi,
Lost
you
it.
just have to refresh
Lost
the
it.
memory in brief and point out. the
Otherwise,
written
Lordship, regarding extension today, I am not saying, otherwise that pair was made before your Lordship.
It's not there in
That
the
was, no, that
record.
was made before
You
your
see, if
Lordship.
it was rejected, I
Lost
could have understood,
Lost it.
but it doesn't look
And
proper.
there was an application for the other side for vacation.
All right.
Anyway, on
Since the
27th.
matter, Mr.
first.
Gogoi, since the matter is already heard and it's part
Lost.
heard, in all fairness, if there was an interim order continuing, it can be, there is nothing.
27th.
All right.
Here I am appearing as amicus curiae, Lordship, and I have seen in the records, Lordship, record shows, Lordship, he was convicted for 6 years. And he is probably already served out that sentence. So probably.
Yes, ma'am. 6 years, as per the, it has been given in the cause list, madam. It says 6 years, 1 month, 23 days, madam.
No, but then what
And
will happen?
Then if he has served out the sentence, perhaps he will be placed in the detention camp or other
Yes,
will be
and
deported.
because that stigma is there,
Yes, but yes, stigma is there.
so how this appeal will
But-
become infructuous?
Yes, if it can continue, madam. Yes, that part is Lordship is of, yes,
How will it become? Tell me,
Yes.
enlighten the court.
yes. Only thing, well, yes,
Even yesterday, in one of these orders, I had
yes. There has to be some order in the appeal.
Correct.
That will not become infractions, but if they do not want to pursue, your lordship can.
It's a appeal which is
Yes.
which is the right. You are the amicus.
Yes.
So is there anything before this court to show that he wants to withdraw the appeal?
No, therefore I have prayed before your
How
lordship
can
to
you
make a call for a report.
report from whom?
Report from jail if he is there or not.
Report
If-
from whom?
From the jail authorities
About what?
about the present status of the convict, lordship.
That
Whether-
I can call, but if suppose it says that he has already he's already undergone the term,
Lordship.
does it change anything?
No.
Regarding merit, my lord. It is.
It doesn't change.
Right.
Enlighten me. I may be wrong. I don't know. I'm
No,
asking
yes,
you
yes,
both.
my lord.
Will it change? Because this conviction, that stigma,
Lordship.
will always be hanging
Yes, yes, my lordship is correct. If
on his head as well as his family members.
yes, even if
It might cause prejudice
yes,
to them.
Lordship.
I don't know what is the merit, but
Lordship.
suppose tomorrow we find
Lordship.
merit in the appeal,
Lordship.
yes,
then the findings has to go.
Lordship.
Of course, we can't do anything with the conviction
Lordship.
since he's already undergone.
undergo
But the findings,
only finding.
Yes, many a times some accused persons file
I
criminal
can
appeal.
keep this matter for tomorrow or Friday. You may, both may
Yes,
examine it and come, get back to me.
lordship,
I want to be also clear on that.
lord,
All right?
that is there.
Because sometimes the accused serve out the sentence, in spite of that, they file appeal because lordship, they lordship do those government job that will affect their service
Yes.
career also.
Yes, not
So those
only,
things are
not,
already
not
there.
only government job, even if he's not a government person, if he has a daughter,
Yes, yes,
if he has
Those things will
so
come.
many
Yes.
things might come.
Yes.
yes.
So that in fact, that sentence probably will not be
Not-
there.
No,
in
then-
criminal
It
appeal.
has to be some order in the appeal.
Okay.
That
He
is-
filed it's
that
a
is-
statutory appeal.
Lordship.
There's a
How
statutory
can
appeal.
the court, what is to be done then?
My prayer before lordship is that one report may be called and in the
Mr.
meantime-
A. Ahmed, learned amicus curiae, as well as Mr. P.
MP Goswami.
NP.
Mridu Pawan Goswami.
MP Goswami, learned APP for the state submits that perhaps the appellant has undergone the term and accordingly requests for calling a report from the jurisdictional jail authorities
Lordship.
as regards the status of the appellant. Let registry call for
Yes.
the report from the jurisdictional jail authorities as regards the status of the appellant convicted in session case number 20/2019 within bracket GR case number 61/2019
Lordship.
and Bokazan PS case number 17/2019 registered under section 14 within bracket A, B of the Foreigners
Lord.
Act. Relist after 4 weeks on a date to be fixed by the regulator.
Lordship, registrar further directed to furnish a copy of the relevant papers to me, lordship.
You have not been.
No, no.
Mr. Ahmed further submits that the relevant documents pertaining to the appeal memo and the appeal memo has not appeal memo along with the relevant documents have not been furnished to him till date by the registry. Let the same be provided by the registry forthwith to Mr. A. Ahmed, learned amicus curiae.
Online.
Me please, Your Lordship. I'm for the petitioner. I will
But,
allowed to proceed the case, my lord.
13.
They-
13, my lord.
There is an amicus
and like
also.
they-
And go.
oh,
Yes, what happened? Why
Yes,
there's
well-
an amicus?
just now, he said that there is some discrepancy in the notebook he has, he was given by the.
Alright, but since amicus is there and he's not here today, we'll have it on another date.
Lordship.
An accommodation has been sought on behalf of Mr. Surajit Das, learned amicus curiae. It has come to the notice of the court that Mr. Das was waiting in the court.
first up, he is there.
Court, however, it appears that, however, it has been informed that due to another matter being called in another in relation to another matter in the court is not available in the courtroom as of now at this moment. Stop. Relist
My lord, my name may be recorded.
Relist. When? When?
After a week or two,
Get-
within
date
a week or
did-
2 months.
Number 14.
Here, my lord, I have gone through the record.
Number did
I have gone through the record, but just some time ago, my lord, the
None
petitioner.
appears for the appellant when called. Relist.
Lord,
Date did relist.
into my file there.
Item number 16.
None appears for the petitioner on call. It's about MP Goswami Diripa for APP. Relist. None appears for the petitioner on call. Relist.
Number 19.
Mr. Das, your matter, we have posted it on another date.
Yes, my lord, the difficulty is that, my lord, the paper book has not been properly framed, my lord.
Acha.
Even the FIR is also missing, my lord. So, my lord, let the registry submit a corrected, my lord, paper book, my lord.
Get hold of the other lawyer who was appearing. I'll change that order. Get hold of that lawyer.
My lord.
He just went out. Get hold of.
Number 19.
Your junior will know. Oh, he's there. You had a. Yes, yes, yes. Mr. Das, you are appearing in item number. Surajit Das matter. Item 13.
My lord.
Yes, it has been in 13 filed to about 13 order to Kanidia. Heard Mr. Surajit Das, learned amicus curiae. Also heard Mr.
N. Borua,
N. Borua, learned counsel for
the petitioner.
So
Appellant. Appellant.
How come
Probably
that
they did not appear on some days when that is the court appointed number.
appellant also heard Mr. MP Goswami learned APP for the state respondent. Mr. Das points out that the paper book prepared by the registry does not have the FIR and
The paginations are
and
also
pagination is all right. What else? Pagination is okay. What else?
There is a, my lord, complaint petition.
there has not been an next one in the paper book.
Complaint petition is annexed
Complaint petition.
in the paper book.
Annex.
If the complaint petition is there in the appeal memo, then why?
Well, if your lordship can see page number 1 in the index, it has been mentioned as FIR.
And that there is some defect in the paper book.
Yes.
Let registry verify and clear the defects.
Yes.
As defects. So relist after 2 weeks and they did job. The parties are at liberty to point out the said defects before the registry.
I'm sorry. In item 18, name may be heard, Lordship. In item 18, my name may be heard, Lordship. My senior is on legs.
Your name.
SK Chetri.
Mr. S.
On behalf of N. Uddin.
Mr.
SK Chetri on behalf of N.
SK
Uddin.
Chetri on behalf of Mr. N. Uddin seeks accommodation in the matter. Prayer is not opposed. Relist. Next.
Obliged.
19. Anyone appearing?
No.
None appears for the petitioner on call. Heard Mr. So-and-so at APP. Relist on such and such date.
Number 20.
None appears for the petitioner on call. Heard so-and-so. Relist on such and such date.
Number 21.
None appears for the petitioner on call. Heard so-and-so. Relist on such and such date. None appears for the petitioner as well as respondent number 1.
So Lordship, the senior counsel Z will be here any minute, just seeking accommodation for some time.
An accommodation is sought on behalf of Mr. Jed Kamar, Learned Senior Counsel, Senior Counsel appearing for the petitioner. Prayer is not opposed. Relist.
I'm not for the NCB.
Acha.
I'm sorry. Lordship, he'll be here just any second.
It is noted that there is no representation on behalf of the Standing Council NCB. Relist on such and such date. Next.
Lordship, we have misplaced the file and we could not contact our petition client to seek instructions.
Yes, your name?
B. Shaha.
MSB Saha, Learned Counsel for the petitioner, submits that inadvertently the brief has been misplaced and is trying to reconstruct the file and accordingly seeks accommodation in the matter. Prayer is allowed. You don't have to contact your client. You take a copy of the court's file and you reconstruct. Yes, when?
After Bihu.
After Bihu. Did your interim, if any, shall continue till the next date of listing.
Number 25.
May I please, Lordship? Lordship, kindly pass over the matter for the time.
No time being. Another date. When?
Please, Lordship, we make a mention in the morning. I am on behalf of M. Haloy.
Huh?
Mr. M. Haloy.
Okay, okay.
I am on
All right.
behalf of Mr. M. Haloy. We made a mention in the
A
morning.
mention has been made on behalf of Mr. M. Haloy, Learned Counsel, appearing for the respondent. Stop. In view of the aforesaid mention, list this matter after 2 weeks.
After 2 weeks,
On a
Lordship.
date to be fixed by the registry.
Deeply obliged.
Mention is made to adjourn the matter. 20.
Well, I'm for the 28, item number 28.
27 to Hoigol Nipil. Yes.
Yes, my lord, in this matter, we have challenged the Learned Special Judge, my lord, and charges frame under section 3 and 4.
Of the PMLA Act.
Yeah, my lord, and we are the co-accused, that the prime accused, my lord, though they were discharged, my lord, who involved, actually seriously involved in this matter, they were discharged, and but proceeding initiated against
Ms.
us.
Dan, you ready?
Ready.
Yes.
And thereafter, my lord, and against that order, my lord, we challenged under before this court, my lord, and this honorable court has granted interim protection to till date, my lord. And by that time, my lord, the prime co-accused who were discharged by PM Enforcement Director challenged that's item number 29. That is item 29.
Who is appearing in 29?
My learned friend, my lord.
29, my lord, the respondent number 2 has already on the last of the number, your lord,
Yeah, expired. No?
including is awaited. So
Awaited.
One of the prime accused in the matter, my lord. He expired, my lord. And one learned senior in this case, M. Bora is appearing now. They are not.
Who is appearing?
My lord, senior advocate Angshuman Bora is presenting
He's
that.
not here.
They, my lord, is not available.
Not available. Even I can
Fix another date. I think he is not.
yes, my lord.
Yes, ma'am.
Yesterday also a couple of his matters were being mentioned. I think he's out of station.
Yes.
It is a prayer is made on behalf of Mr. A.M. Boral and a senior counsel appearing for the respondent number 2. Respondent number 1 in criminal revision petition 77 of 2020. On the ground that he has due to personal on the ground of personal difficulty. Prayer is allowed. Relist.
My lord, sir, short date may be given. Yes, ma'am.
10 April, my lord. My lord, item number 28 is interim order till date 10 April.
Interim order, if any, shall continue till the next date of listing.
Deeply obliged.
All done? Matidia. 32. Yes.
Please, your lordship. This is the criminal revision lordship against the conviction under 392 lordship of 3 years. 3 years of conviction. Lordship,
Yes. Conviction is under?
under section 392 of IPC, 3 years rigorous imprisonment and pay fine 300 rupees, Lordship.
Okay.
And the tribunal, while convicting the petitioner, had preferred the appeal, Lordship, and the judgment of the appeal is page number, Lordship, come to page number 29, Lordship.
All respect, madam, I make it clear, madam, I have not gone for the answer of this case because there are other cases which I have gone through, but it was. It's a very big one.
Today is when? Tomorrow?
Lordship, I will.
Tomorrow or Monday?
Lordship,
Friday?
Tuesday.
Next Thursday or Lordship.
All right.
I'm obliged.
Heard Miss MS M. Nirola, Learned Counsel, appearing for the petitioner. Also heard Mr. MP Goswami, Learned APP for the state respondent. Mr. MP Goswami, Learned APP seek some accommodation in the matter in order to go through the case records. Stop. Prayer is allowed. Relist.
27.
Yes.
Well, I have an unusual item number 14, my lord. That item was called for, I was in court number 9, my lord.
Order pass.
My lord, one thing, my lord, just my lord. In this case, my lord, the appellant has already expired, my lord. So my lord, I think this
It's
matter
a criminal appeal.
my lord, criminal appeal. The matter stands abated, my lord.
How can it be?
Appellant.
আপনি এটা কাম করবেন ইনস্ট্রাকশন চলাব বিচাৰিছে
He died.
He died.
Then it can be abated. I think.
My lord, he died.
If my lord, there are two parts in the sentence when it is abated, my lord. If it is for the pecuniary, then it can go, my lord. Otherwise, it is.
All right, we'll see on the next date then.
Yes.